21. Use the microphone, please. Yes. Pablo. Yes. Yes. Okay. Government will fix another date after the vacation. It is submitted. That's Sri M. H. Laskar Learned Council is under bereavement. Full stop. List after the summer vacations. Yes.
For the site, a backman maximum 15 lots. Matter taken after the vacation.
15.
Lots. The applicant has accommodate table engage another one.
19 matter. You are for whom? You are
For
for
the
the
applicant.
for enhancement or what? 19 matter. Why are you seeking time? On prayer on a prayer made on behalf of the appellant. Matter is adjourned to be listed after the summer vacation. Yes.
8 with the lordship. I beg to pattern number 8 lordship.
Yes.
I am for the respondent lordship.
Hmm.
I beg to detail. Return account for the pay lord.
These are 14 matter. No,
Lordship, yeah, the place for medical information to the lord.
Hmm?
Tomorrow lord. Yes, sir.
Who has a problem?
Page 4 lord. Tomorrow 1, 2 and 3 lord.
We'll have it tomorrow.
Sure.
A prayer for adjournment has been made on behalf of the respondent. Full stop. However, considering that this appeal is of the year 2014, while declining the aforesaid prayer, a short accommodation is granted, directing listing of this matter tomorrow. Date. Tomorrow, no.
Okay.
Thursday.
Problem.
Day after tomorrow. 20. 20.
I didn't want to cover the list.
Expert 5.
Where is who's for the Union of India? NECGC. None appears for the appellant on call. Para, your name?
Yes, sir.
S. Roy. Sri S. Roy Learned Council for the respondent has, however, informed this court that the sole respondent, who was the claimant, has expired. Full stop. Para, in the interest of justice, the matter, the appeal is of the year 2012. Para, in the interest of justice, let another chance be granted to the appellant. Full stop. Para, list for consideration on Thursday. Full stop. Para, it is made clear that in case of further non-representation, this court would be constrained to pass appropriate orders. Why aren't you here in time? Yes, the claimant has passed away.
Yes, sir. Yes, not me, my lord.
So
Well,
what steps have you taken?
My lord, my lord, only my lord, last night, my lord, has been from my lord.
When did he pass away? 2 years.
Oh, my lord, I was aware of.
It has been abated.
Yes,
2 years.
I'll, my lord, I'll miss this for my lord.
heard Sri G. Goswami, learned counsel for the appellant, whereas Sri S. Roy, learned counsel is present for the respondent. Full stop para. Sri Roy, the learned counsel, has, however, informed this court that the sole respondent claimant has passed away in the meantime. Full stop. Para. Sri Goswami, learned counsel, prays for and is accordingly granted 2 weeks' time to take necessary instructions. List after 2 weeks. List immediately after the summer vacations. I go to Nalai, huh?
But
Item 2.
Yes.
May I please? Let us be careful with the fight. Yes, keep order for the party that in order.
Kindly use the microphone. Use the microphone. Come for nine. Niki. Volume to boot como asani. Yes,
One more.
yes, I think it was less amplified.
Right.
Yes, make a
Right.
mention.
Your lordship will find the imprint order at page 9.
9.
It starts from page 9. Let
You are aggrieved by the adequacy of the amount
no, my lord, our claim petition has been dismissed,
or rejected.
rejected.
Page.
Imprint order, your lordship will find at page 9, annexure A. Lordship may come to page 11.
This is
The
the-
issues have been framed at page 11.
Dated, this is dated what? Dated, what is the date? 17/4.
17/4/2012.
Judgment of RCT.
Arthur. Guwahati Bench.
Yes. What happened? Please read.
It is, my lord. This court judgment, my lord, kindly turn to page 11. At page 11, your lordship will find the issues were framed. I am reading the issues, my lord.
Now, why don't you read the judgment? Let us have a brief idea of the facts.
My lord, the deceased is the son of the applicant. The deceased was, my lord, his name was Abhijit Chaudhary. He was a passenger with a valid ticket. My lord, he was traveling from Nahorkotia to Borhat. And the train left the station. Immediately after leaving the station, my lord, because of the commotion of the passengers in the station itself, within the vicinity of the station itself, he fell down because of commotion of the passenger.
Okay, then.
In the station itself, my lord, before the eyes of many people, and immediately it was reported to the GRP. GRP personnel also appeared there. They took over the charge of the dead body. Of course, my lord, because of the family.
Please
Condition.
read, please read the judgment. Everything will be clear. Why aren't you reading the judgment?
My lord,
Read the judgment,
Yes,
paragraph,
yes.
page 3, paragraph 3. Respondent appeared in favor.
yes, my lord, I am reading the judgment.
Yes.
It is a short judgment.
First page we have read. Come to
Yeah.
the second page,
Yeah,
page
yeah.
11.
Second page,
Yes.
from para 3.
Yes,
I
yes,
am reading.
yes.
Respondent appeared in answer to the submission issued and filed a written statement containing among other things, that case of the applicant, in that his son fell down from 902 down passenger train on 20.
Okay, we have read. Issues.
Yeah, my lord, then issues. The following
Yes.
issues are framed. My lord, whether the deceased was a bona fide passenger of the train.
Hmm.
Second, whether the alleged incident is covered under section 124A of the railway act. Next, my lord, whether the applicant is entitled for the compensation as applied. And
Yes.
other. So, evidence consists of exhibit A12, A6, R12, R10, and exhibit claim order evidence answers 1 to 2. Heard both the sides. Issue number 1 and 2 were considered together, my lord. I'm reading para 7. Exhibit A1 is a certificate issued by the officer in charge of Tinsukia GRPS stating that Sri Abhijit Chaudhary died by accidental falling from 902 down passenger near Naharpatia railway station on 21st October 2007. It also says that the post-mortem was not conducted on account of the request of the members. Exhibit A3 is the office memo certified to be true copy of the officer in charge of the Tinsukia GRPS. It is stated 21st October 2007. It says that one male person aged about 26 years was run over by 902 down train at about 8:15 hours, and by the memo, officer in charge of GRP Tinsukia was requested to arrange for disposal. Entry in that shows that the Tinsukia police received the information at 8:45 hours by telephone. Exhibit A2 is the DD entry. Exhibit A4 is the application for dead body made by the Bishwajit Chaudhary to the GRP Tinsukia, stating that he is the brother of the Abhijit Chaudhary involved in the train accident and requested the police to deliver the dead body to him. Exhibit A5 is the death certificate. AW is the applicant. Evidence given by him shows that he was not with the son at the time of incident. He has not witnessed the incident. That shows that evidence is helpful only to find out that the person who died in the incident is his son and no post-mortem was conducted of the body of his son. AW2 is the brother of the deceased. According to him, he and Abhijit Chaudhary went to Naharpatia railway station, and Abhijit Chaudhary purchased one ticket and boarded the 902 down passenger train, and on way he fell down from the running train due to rush and commotion of passengers and received previous injuries and died. During cross-examination, he admitted that he is the relative of Abhijit Chaudhary. Though he thought that he saw Abhijit Chaudhary purchasing the ticket, he could not say the fare paid by Abhijit Chaudhary. According to him, soon after the train left few meters, he heard hue and cry, stating that one person had fallen down from the train, and after crossing 2 meters, the train stopped, and somehow he managed to see the fallen down person who was dead, and post-mortem was not conducted due to their family tradition. While considering the evidence given by the applicant, certain things has to be borne in mind. Incident was soon after the train leaving the railway station, and son of the applicant died as train bearing number 902 ran over the son of the applicant. The possibility of a person falling from a train and train by which he is traveling running over him is practically impossible. Situation will be different if he is run over by some other train. I am of this view when the position of the door of the compartment and the position of the railway track is considered. In my opinion, a person falling from a running train can either fall close to the railway track or few feet away from the railway track. He cannot fall over the track. No parts of such a person's body could go into the track. In view of the case advanced, applicant was bound at least to produce the inquest report so as to conclude what the injury that visited the injury. Non-production of the seen measure inquest report speaks volume. Case of the respondent that much has to be read for the absence of post-mortem examination on the body of the son of the applicant as married. In my opinion, acceptance of the case advanced by the applicant will amount to negation of common. Exhibit RC is a report of the station superintendent to the officer in charge of the Isuke police station. What is stated there is that at 8:15 hours on that day, one person was run over by 902 down train. The station superintendent need not give a false statement or a false report to the police. Exhibit R7 is station master's diary. In a case like this, the preliminary burden is on the applicant to establish that his son died in an untoward incident. The facts and circumstances available in the case leads to the conclusion that this was not a case of untoward incident, but a case of train running over the son of the applicant. Contention of the applicant that AW2 has given evidence with regard to the purchase of the ticket and boarding of the train has to be viewed bearing in mind the fact that a witness may tell a lie, but circumstances cannot. I am of this view because of the reason that the possibility of a train running over a passenger of that train who fell down from that train is an impossible act. While fantasy are required to accept that case, the question whether the deceased was a passenger and whether he had purchased a ticket could have been proved by the applicant by producing the inquest report. Applicant, for the reasons best known to him alone, decided to suppress those which, in my opinion, is a circumstance which calls for withdrawal of an adverse inference. Suffice it to say that I am of view.
Okay, we have read. Yes.
My lord. So, my lord, this case, my lord, your lordship will consider there are 13 words used by in connection of this type of cases, mainly 3 words: run over, knock down, and fall down. These 3 words are frequently used, my lord, but everybody is confused. To understand the difference between these words, run over, knock down, and fall down. My lord, in series of judgment, it has been seen, in one judgment, I'll to your lordship,
Please.
it is by Justice S.K. Sharma from, he went to Supreme Court from our High Court, your lordship will be knowing, and Markandeya Karchi. Detailed discussions have been provided there in the judgment regarding, my lord, the railway, this compensation is given, my lord, under the Railway Act and the Railway Claims Tribunal Act 1987. It's a piece of welfare legislation. My lord, in this judgment given by Honorable Justice Sharma and Markandeya Karchi in the Prabhakaran case, Union of India versus Prabhakaran case. Here it has been,
Citation?
my lord, citation is 2008, volume 9, SCC 526.
Yes.
Interesting citation. In this judgment, my lord, I will first draw your lordship's attention to paragraph 7. Paragraph 7, my lord. I am reading. The tribunal, strangely enough, held that TW2 was an interested witness who, if he was present on the spot, he would have definitely helped the station master in removing the dead body from the railway track. Further, the police would have definitely recorded his evidence. For this reason, the tribunal disbelieves the evidence of PW2. We are, however, of the opinion that there was no good reason to disbelieve PW2 because there is nothing to show that he had any motive to give false evidence or that he was an interested witness. Further, his evidence,
Now, how does it help you?
my
This paragraph, how does it help you?
my lord, the latter
Yes.
part of this paragraph.
Yes.
Yeah, then, my lord, I'll read only that relevant sentence. Moreover, merely because
No, that is okay. Here,
common sense, my lord, in our case has been dismissed on the
in
basis of
this case, it is not dismissed because of lack of evidence from particular person. Your claim has been disbelieved because your claim is that he fell from the train and was run over.
Yeah.
You did not produce the inquest report.
No.
You did not prove the postmortem. In fact, there was no postmortem because of the request of the family members. In view of that, is it possible for a person to fall from a train and being run over by the same train?
Yeah. Yes.
That is the,
my lord,
on that, if you want to show something,
yes,
and in absence of any report, scientific evidence that it was proven, and you did not, there was no postmortem.
Right.
And you are not denying or your admitted cases that he was run over by the train. Dying out of injuries by falling, that's a different matter. And he may still be run over by a falling train. But for that, you have to prima facie establish that it's possible. This is the report. You have not proved the report, postmortem report.
my lord,
And the tribunal has
Yes.
made some discussion. He has not reached to the finding
My lord,
without discussion.
I was referring to this paragraph because, my lord, our impugn judgment has been dismissed by applying common sense. Here, common sense has been discussed here
Where?
in this paragraph.
Which paragraph?
Yes, this paragraph 7, the last part.
Yes. Where is it?
Moreover, merely because the police did not record his statement does not mean that he was not present or gave false evidence. It is common knowledge. It is
Yes.
common knowledge that in our country, often there is a large crowd in the railway station
Yes.
platform. And it is simply not possible for the police to take the statements of everyone there.
So how is it connected?
I'm submitting. In our case, my lord, the tribunal has held this, it has given the finding that by applying common sense, it can be held that a passenger falling from the train cannot come to the
Track.
track and run over by the same train.
Yes.
Common sense has been applied. My lord, before going to the judgment, citation, some provisions of the Railway Act is relevant.
Please.
Your lordship will consider.
Which one? Well,
Yes. My lord,
you're having the 1987 Act.
yes, my lord, 1989, Railways Act, 1980.
Not Claims Tribunal Act. Railways Act. Railways Act.
Claims Tribunal Act will not later.
Okay.
Now
1989 Act.
Railways Act.
Okay.
I am referring some section from the Railway Act,
Hmm.
1918.
Yes, please. Which provision?
Yes, my lord, here. Section 229,
229
yes, definition, section 229.
or section 229. Okay.
Section 2, subsection 29.
Passenger.
Yes, definition of passenger has been given here. Passenger means a person traveling with a valid pass or ticket.
Yes.
So this is the definition of the passenger.
Hmm.
Now, my lord, section 55. Section 55,
Yes.
Section 65.
Yes,
Section 55, your lordship will
prohibition.
find, yes, my lord, the prohibition part, section 55, prohibition against traveling without pass or ticket. No person shall enter or remain in any carriage on a railway for the purpose of traveling therein as a passenger unless he has with him a proper pass or ticket or obtained permission of a railway servant authorized in his behalf for such travel.
Okay,
So, my lord, without pass or ticket, nobody can enter even into the premises of the railway station. At least platform ticket. If not the journey ticket, at least platform ticket has to be worth for entering. So this is along with his brother, they entered into the platform. The deceased boarded the train. That was also seen by his brother. His brother accompanied him to the railway station. He saw purchasing ticket. Then he boarded the train. That has been stated by the evidence. Witness.
Mr. Mullah, if you are saying that without ticket, you cannot even enter the platform.
Yes,
Did the brother buy a platform ticket?
my brother.
Yes.
My lord,
Did he say that I got
Yeah.
a platform ticket for myself? He got a ticket. He never went to the ticket counter.
no. He stated in his evidence, my lord.
No, if you're
Yeah,
making an
yeah.
absurd kind of an argument
My lord,
that you need a ticket, without a ticket you cannot even enter.
Yeah.
There are hundreds of persons entering unauthorizedly. That is the
unauthorized.
law.
My lord,
If you
yeah.
violate law, are you saying that because of the law nobody violates law?
Yes, my lord.
You
that's
see
not-
90% of the passengers of the persons who enter the station
yeah,
to
yeah.
leave, they do not have the platform ticket.
My lord, that's what I'm submitting.
Where is your ticket?
My lord, I'm
Where is your ticket?
yes. My lord, ticket was lost. After accident,
And you
after
are
a-
making a submission that you have to presume that he had a ticket because of the provisions of law.
my lord, there are series of judgments. I will show your lordship that in all cases of this type of accident, ticket is not found, but circumstantial evidence.
This court has passed judgment.
Right.
It may not be possible for a deceased carrying a ticket in his
I'm
pocket to exhibit the ticket. This court has held in appropriate case.
My
But here it's on a different footing. It's
Um,
not because you did not have a ticket.
no, my
That is not even the issue.
yes,
Let us assume that you had a ticket.
Yes, yes.
Not produced. But how did you die? The claimant said that his son had passed away because of being running over by a train, and he was traveling in the same train.
Yes.
Tribunal says that in absence of the post-mortem report, it's difficult to believe that he fell from the train and he was run over by the same train. And we find that there are sufficient materials to come to the conclusion. He has given reasons that when the platform is there, if you fall from the train, you may still succumb to the injury, but you cannot be run over. It's an exceptional case. And to make it an exceptional case possible, you have to at least prove the post-mortem report, the inquest report. You have done nothing. GR
Yeah.
case was registered.
postmortem report, regarding postmortem report, we have stated, my lord, it has been given in the judgment also, in the impugned order, it has been mentioned that postmortem was not done because of the request of the
You had
family.
requested. So that is
Family
out of
petition.
that is out of
Yes, my lord.
contention that
So
you
the-
cannot.
so the- my
So
lord,
at least the inquest.
my lord, one thing is certain that the incident took place in the railway station itself, in the broad daylight. And my lord, the dead body has been found, the injured was traced and found that he died in the station itself. So my lord, two things maybe, there may be two possible interpretation of the situation.
Yes.
First one is that he was a passenger, he purchased tickets, as the witness has given the evidence,
Correct.
that he saw him purchasing ticket and boarding the train.
Hmm.
So, first interpretation, possible interpretation would be that he purchased ticket and he tried to board the train or he boarded the train. And he fell down, his dead body has been found. So, my lord, easily it can be, it is possible to hold that he was a patient and he boarded the train. Thereafter, he fell down. The first possibility, my lord. The second possibility may be that without ticket, he boarded. That possibility may be there. Without ticket. He
R-
boarded the
R-
train.
R1 say, R1, exhibit R1
Yes,
says that no ticket was purchased.
R1, my lord, R1 is the witness of the respondent.
Yes, from Naharkutia to Borhat, no ticket was issued on that date.
That evidence is there, my lord. But our case is that, my lord,
See, you say that you had purchased the ticket.
Yes.
It was seen by the brother.
Yes.
Brother doesn't know how much fare he has paid. That is
Yes.
okay. He may not know.
I may not-
That is possible.
Yes.
You will not ask how much pay.
Yes.
But you did not have not produced the ticket. That is also going to the extreme case. In a given case, you may not be able to. But there are contrary evidence that no ticket was issued from Naharkutia to Borhat on that particular date.
all right, my lord, assuming for the time
See,
being, that-
first is a sine qua non that you have to be a ticket passenger, bona fide passenger having a ticket
Right.
or a pass.
Right.
You have just read who is a passenger under 229. You need to have a valid pass or a ticket. The deceased did not have a valid pass or a ticket.
my lord, R1, assuming for the time being that he has given the evidence that there was no ticket sold from Naharkatia to that station, my lord, ticket was not sold. That evidence has been
Ran
given.
over. That R6 says it was run over. Run
Well-
over body is lying by off the track.
My lord, that is what I was submitting to your lordship, that my lord, after getting this type of incident report and
Yes.
after getting the dead body,
Hmm,
my lord, two things may be inferred.
yes.
Two things may be inferred, my lord, that as the dead body was found in the railway station itself in the daylight,
Hmm.
so it can be inferred that he purchased ticket or without ticket he boarded. Two things possible, my lord.
Yes.
Both the things are possible. Either purchasing ticket or without ticket. But one thing is clear that he boarded the train and fell down. As his body was found in the station itself. Now the question is, my lord, that crucial question that he has, that if he has been run over by the same train, it's not possible. Maybe that by some other train. Maybe that by some other train he.
That is not even your case.
Yeah, that is not our case.
You cannot now go for a different presumption. That is your
No,
pleaded
no,
case.
no. Our
He
case
fell down from the train, he was run over.
yes, he fell down, my lord.
Fell
That is
down.
our case. He fell down from the running train.
Yes.
That's our case.
And he was run over.
He has been run over.
Now run over is
Run over, my lord. That is what I tried to make clear.
Mm.
My lord, these three words: run over, knock down, and fall down.
yes.
These are confusing words. Our case is clear, my lord. It's a case of falling down. He fell down from the train. Thereafter, after falling down, my lord, the victim may come into the track. The tribunal has held that it is not possible by applying our common sense. We know that after falling from the train, the person cannot come back to this track and run over by the same train. My lord, the accident takes place under what circumstances, in which condition of the location, everything is uncertain. So, my lord, the basic thing that the person boarded the train, he fell down. Now, one question may be raised by the railway that he was not bona fide passenger. He did not purchase ticket. Your lordship has already shown that R1 has given the evidence that no ticket was sold in between the station. So, assuming that that evidence is there, But from the other side, my lord, we may think that this person went to the railway station, he boarded,
Without a ticket,
assuming,
without a ticket,
assuming for the time being, my
then
lord.
he'll get the compensation.
No, my lord, time being.
No, if you assume, then that assumption is meaningless, because if you go ahead with that assumption,
my-
you are getting nothing.
All right, my lord. I agree with
You
your
have to
lordship.
be a bona
I
fide
agree with
passenger,
your
you need
lordship.
to have a ticket.
My lord, I agree with your lordship that without ticket, traveling and falling down will not get any compensation. I agree with your lordship. But my
No,
lord,
it's not it's
no.
not agreeing with us, it's the law.
my lord, kindly see, kindly your lordship will consider TT, GRP, RPF. What is their duty, my lord? What they are doing? Their duty is prohibition section. I have already shown your lordship. It is prohibited for any unauthorized person to enter into railway station without ticket. How he reached the railway station?
Oh, so
How he got
you are
board the railway
trying to advantage,
railway
take advantage of your own wrong.
My lord, no.
You enter a railway platform without a ticket and you give fault upon them. What you are doing?
My
Why
lord,
didn't you,
my
why didn't you prevent me from entering?
my lord, without ticket,
Mister,
my lord,
there are certain limits in your, while making your arguments. Don't make absurd kind of arguments like this. Are we here for adjudicating that purpose? What the TT is doing for allowing persons to enter without a ticket?
no, my lord, kindly,
Or are we adjudicating a claim?
my lord, kindly see the penal provision is
Yes,
also there.
yes, Mr. Goswami.
Penal
If you have
provision is-
anything new to say, otherwise we have heard you. Mr. Goswami.
My lord, I want to discuss.
Yes.
Not a bona fide believer. My lord, as per his claim, my lord, there's my lord, he was traveling from Naharkoti to Bharat. And my lord, as per urban, my lord, both people were sick, my lord, from Naharkoti to Bharat. And my lord, to that effect, my lord, this was also kept. Second thing that was topic is putting down another random. And my lord, Carson, my lord, falling down from train, my lord, cannot come under the heat of the. Thirdly, my lord, he has not produced the my lord, increase. My lord, to that effect, my lord, I would like to this my lord, this document, my lord, inalienability of tax. This my lord, in this case also, my lord, at first inference was drawn, my lord, for not producing the my lord, noting the evidence, my lord, in his head, my lord. My lord, para 17.2, my lord. There are 17.2, my lord.
This is what, is it reported? AIR
Report-
2019.
Yes.
Pre-SCC.
Yes.
Pre-SCC. 572.
Right.
Para?
17.2, my lord. My lord, cross may kindly come to 17.1, my lord.
17.1.
Right.
Yes.
My lord, it is burden of proof when body found on railway premises, definition of passenger.
Yes.
So, my lord, I'll come to 17.2, my lord.
Mm.
Here, my lord, in Jeta Naga Lakshmi Parvati Supra, same view was taken by a single judge of Andhra Pradesh after referring to the provision of Evidence Act as follows. So far, section 101 of the Evidence Act 1972, it's clear that applicant having come to the court asserting some facts must prove that that the date of the disease has taken place in an untoward incident and that the death occurred while the disease was traveling in a train carrying passenger as a passenger with valid ticket. Therefore, having asserted that the disease died in an untoward incident and he was having valid ticket at the time of his death, the initial burden lies on the applicant to establish this same. If initial burden of the applicant never shifts unless the respondent admits the assertion made by the applicant, such evidence is lacking in this case. Except the oral assertion of AW1, no evidence forthcoming on behalf of the applicant. The court may presume that the evidence which could be and not produced would if produced, be unfavorable to the person who withhold it. The base evidence rule which governs the production of evidence in court requires that the base evidence of which the case in its nature is susceptible should always be produced. Section 114(3) of the Indian Evidence Act 1972 enables the court to draw an adverse presumption against a person who can make available to the court but obstruct the availability of such evidence. The claims tribunal, upon considering the material on record, rightly dismiss the claim of the applicant. My lord, here also in this case, my lord, in 14.2, 14, my lord, para 14, my lord, adverse inference was drawn by my lord, by the tribunal, my lord, where it stated that my lord, inquest report was, my lord, not put its number one, my lord. Now, my lord, coming to my lord, a para, my lord, 17.4, my lord,
Of the same judgment.
is, my lord, same judgment. My lord, 17.4, my lord, may I read that?
Yes, please.
We thus hold that mere presence of a body of on the railway premise will not be conclusive to hold that the injured or diseased was a bona fide passenger for which claim for compensation could be maintained. However, mere absence of ticket
Yes,
would
yes, we have read this.
my lord.
In a
In
given
initial-
case, he may not have the ticket. It may
my
not be
but-
possible.
my lord, next line, my lord, initial burden will be on claimant.
Now we have read this.
My lord. So, my lord, this is my.
It'll be based on case to case basis.
My lord, my lord.
So, but here you have a rebuttal evidence
Right.
that no ticket was even issued
Yes.
for Naharkutia to Borhat on a particular day.
Right.
That's all?
Right.
Yes, anything in rejoinder?
My lord, and my lord, beginning my lord, 17.3, my lord, in another case was my lord, cited here, my lord. In Kamrun Nisa, my lord, from the circumstances appearing in that case, it was held that there was no evidence that the disease had passed the ticket. In the in the given fact situation of the case, the court inferred that it was not a case of untoward incident, but case of runover. It observed. The aforesaid reports also revealed that the body of the disease has been cut into two pieces and was lying next to the railway track, my lord. This is, my lord, where, my lord, lordship, my lord, if my lord, found on the track, my lord, it says that, my lord, it cannot go inside the track, my lord. It is falling down. This is, my lord, another answer of your lord.
Let's see the claim petition. Judgment. Mr. Goswami, from where do you get that he was run down,
Run over by
run over?
Art sub- Art 6. Only it's me. Or put that at 16 hours. Art 6 match. Art 6.
Or 6? You had contested the claim, R6, yes, please, on duty,
On duty hitman of Nagarkoti quoted
run
at
over.
8:50.
On duty gateman, one male person run over by so-and-so.
This third signal can get on death. None of our body is lying by of the track. RPF starts to catch the
Watch the body,
That's
not fetch, watch.
Fetch.
Irons to early disposal of the same. Where is your written statement? Did you filed a written
Yes,
statement?
my lord, I have my lord. Yes.
আরো এখন আছে নাকি এখনকার?
My lord provided by the my lord. Your file, my lord.
Who is Dulal Chaudhary, Mr. Mullah?
Lordship.
Who is Dulal Chaudhary?
Dulal Chaudhary is PW2,
No, no, that is, no, who is he?
that's here.
Who is he?
EW2.
Written statement we have got.
In paragraph 17, my lord, there
No,
is a
এখানে নয়।
statement of EW2.
Just a minute, please. Right.
Yes.
Okay, yes, anything?
My lord, Mr. Dulal Chaudhary
Yes.
is not brother of the deceased. He came to the railway station along with the deceased. And he saw the purchasing ticket and boarding the train. He's not his brother. His brother submitted, brother of the deceased submitted application to the CRP for getting the dead body without
No,
conducting.
that we have seen. No, no, we were just trying to know who is the Dulal
So
Chaudhary.
he is not relative.
He is not related,
He is
okay,
not relative, not brother.
okay,
He is totally a different person
yes,
who accompanied the deceased to the railway
yes, yes,
station
yes, yes,
and
yes.
saw the purchasing. My lord, one judgment, your lordship will be.
Citation, name,
Yes, my lord, it is, the citation is 2017,
2017,
SCJ,
ACJ,
SCJ 2447.
Calcutta High Court.
Calcutta High. My lord, yeah, in paragraph 21, your lordship will find
Yes, paragraph.
paragraph 21.
Yes.
In this paragraph, it has been held, my lord, that personal knowledge could not have been relevant for rejection of a claim for compensation. The tribunal, in this case, my lord, tribunal rejected the claim petition on the basis of personal knowledge. The case was examined by applying personal knowledge and claim petition was rejected. High Court held, no, personal knowledge cannot be relevant for rejection of a claim petition of compensation. That has been held by the judge.
How is it relevant?
My,
How is this relevant?
my lord, in our case also, the impugned judgment has been passed on the basis of personal knowledge of the tribunal. It has been said, finding has been given clearly that common sense, by applying common sense. So in that way, my lord, while deciding a petition for compensation, my lord, personal knowledge of the adjudicator is not relevant. The circumstantial evidence, direct evidence, document may be relied upon, not personal knowledge. That is what has been said here.
Awarded about the role of the
Controversial
setting a technical number who presumably was the officer who could claim knowledge.
My lord, one more judgment come up. Judgment of Andhra Pradesh. That is short judgment. In paragraph 6, my lord, kindly turn to paragraph 6.
2004
Yes.
ACJ 713.
Yes, 2004 SCJ 716.
Agam Santhama.
Santam,
Yes, paragraph.
Agam Santhamma versus Union of.
Para
My lord, paragraph 6.
6.
I'll take your lordship to paragraph 6 and 7. See? 6. The only question
Yes.
that arises for consideration is whether the finding of the tribunal that the deceased was not a bona fide person. Legal or elect.
Yes.
Paragraph 7.
Hmm.
This issue is already stated not by the division bench of this court in Union of India versus Censo, wherein it was held by the division bench of this court that the burden of proof, I will kindly see, burden of proof lies on the railway to prove that the deceased was a ticketless passenger. It's the burden of the railway. Once, my lord,
How do you overcome the Supreme Court?
once,
How do you overcome the Honorable Supreme Court?
yeah, my lord, I'm
That
sorry.
the initial burden is always of the claimant.
Yes, my lord,
Unless you discharge your initial burden, it will
Initial
never
burden.
be,
yes,
the onus will never shift
my
upon
lord,
the.
initial burden, regarding discharge of initial burden, there are judgments, I'll show your lordship, wherein it has been held that once the applicant proves
Now, Mr.
the
Mola,
initial burden.
Mr. Mola, let us
Right.
assume, let us admit what paragraph 7 has stated.
Right.
But in this case, is it your case that the railways have failed to discharge their burden regarding the issue of ticket? No
Well,
ticket was issued from Borhat to Naharkutia to Borhat on the particular date. Not even a single ticket.
all right, my lord, they have.
This evidence was put to cross-examination.
No. So, my lord, your lordship, no, my lord, the evidence given by a witness can be believed and accepted. My lord, when the witness will come to the witness box and he will offer himself to be cross-examined by the other.
Yes, obviously.
But he had that this R1 has given the report that ticket was not sold, but they did not come to the witness box. My lord, initial burden.
Let us see.
Your lordship has held the main point,
Let's see.
initial burden.
Let us see.
The burden shifts to the railway. Yes, my lord, I agree with your lordship. Burden shifts to the railway only after discharging the initial duty of the applicant.
Hmm.
After proving the initial burden. Here in the instant case, my lord, the initial burden has been discharged by adducing evidence of A2.
Yes.
A2, Dulal Purvat. A2, Dulal Chaudhary, my lord, he is neither relative nor my lord, he accompanied the deceased to the railway station. He had stated in his evidence. He accompanied him to the railway station. He saw purchasing ticket and also he saw boarding the train. So, by this evidence, my lord, the initial burden has been proved by the applicant. Now, after proving the initial burden shifts to the railway station. They have to prove that he was ticketless. He was not bona fide. My lord, kindly see the circumstantial evidence is the main thing. Assuming, my lord, everything assuming, my lord, kindly see one thing, how this man went to that railway station and how he got injured and he died on the railway station. So once the accident has taken place, he was injured, he succumbed to his injuries, dead body was found by the CRP, everything. The station superintendent has given the memo also regarding that incident. So,
No, but
there was
see,
an incident.
accident by a railway per se, will it entitle a person to receive compensation?
My lord, now
What are the basic requirements? That
Yeah.
you have to be a bona fide passenger. Bona fide passenger has been defined under 229. You said one of your friends said that he saw you buying the ticket and he was himself in the platform. He did not say that I got a platform ticket. That is not his stand.
Right.
Then ticket part, we leave it aside. You said that on the strength of the ticket, the deceased had boarded into the, and thereafter due to commotion, due to over passenger, he fell off and he was run over. Is this you are not denying that he was run over?
the other part, my purchasing ticket,
No,
boarding
he
the
was
train.
run over.
Yes, my
The
lord.
fact of being run over.
Run over or
Yeah.
fall down, my lord, your lordship will consider later.
No,
but
he
this-
fell down and he was run over.
My
You are not. We have examined your claim petition, but you have not said the aspect of being run over by the train. You have not denied that.
my lord, my submission is very short and very simple. Purchasing ticket has been seen by the witness. Boarding ticket train has been seen by the witness. It has been given in evidence. Clear. Hereafter, my lord, fall down or run over. Fall down or run over. These aspects comes later on.
Yes.
But he purchased ticket, he boarded the train. If these two aspects are proved, then the third aspect, fall down or run over, Even after falling down, he may be run over, my. He fell down, he dashed against a hard substance and came back to the track and ran over. It may happen so, my lord. It is very, very natural. Your lordship will kindly consider this aspect, my lord, very crucial. It is a welfare legislation, my lord,
Mr.
compensation matter.
Ola, you have said that the reports of the railways were not duly proved. Here we have seen that even your witnesses were not open for cross-examination. They were not cross-examined.
In that case, my lord, I will submit before your lordship.
Records are before us.
Then,
That is
my
why.
lord, it will be a very,
So it will be,
My-
you have to
my-
equate everything.
my lord,
If you are not subjected to cross-examination, you cannot say that no.
my lord, I agree, your lordship. In that case, my lord, it will be a fit case for remand, my. To decide a case by giving chance to both sides.
Remand of an accident of 2007, of a judgment of 2012.
Kindly see compensation matter, the family will be deprived, earning member has died, young son. So your lordship will consider my,
No,
my.
compensation in railway claims tribunal is not a windfall. You need to have prove prima facie that you are a
Right.
bona fide passenger
Yeah,
having a ticket.
Definitely.
Not being able to prove the ticket to one extent, we can still consider.
My
In
lord,
every case, it may not be possible
my lord,
to have a ticket.
my lord, in many cases we have seen, the railway raises the objection on the ground that accident took place, suppose my lord, an accident took place in the night, in the darkness, maybe that in a distant place, not near the railway station. So there every possibility comes that may be suicide. In many cases we have seen, my lord, suicidal case. But as a claim, it comes to the tribunal. Here, my lord, in this case, your lordship will find it is definitely no point raised by the railway that it's a case of suicide. No suggestion even, my lord, from
It is
railway.
required to be a suicidal case.
Yes, it is
You
not,
are crossing over, it
My
may
lord.
be that you are crossing
lord,
the
my lord.
paths
definitely,
and you are run down.
my lord, it is not a suicidal case. We are all sure
That
about
is
this
not even
aspect.
their defense.
The other aspect, my lord, the fall down or run over. Accidental fall down from the running train, or it's a case of run over. These two things, my lord, if your lordship thinks that evidence not sufficient, then my lord, my humble prayer would be before your lordship, it will be a fit case for remand. My lord, let them get a chance to prove.
Yes, please write. The instant appeal has been preferred under section 23 of the Railway Claims Tribunal Act 1987 against the judgment dated 17/4/2012 passed by the Railway Claims Tribunal, Guwahati, in original claims application number. Again, Sailabha, cost title or pra. Repeat, appeal or cost title, huh? By the aforesaid judgment, comma, the claim was rejected. Full stop. The projected case before the tribunal was that the deceased Abhajit Chaudhary, who is the son of the claimant, had purchased a ticket at Naharkotia station and had boarded the 702 down passenger train to Borhat. Full stop. However, due to commotion of the passengers inside the train, comma, he fell down and fell down, as a result of which he had succumbed to his injuries. Full stop. It is also stated that on the request of the family members, comma, no postmortem was done. Full stop. Thereafter, the claim was lodged before the learned tribunal. Full stop. The learned tribunal However, while the impugned judgment has rejected the claim, and it is the legality and correctness of the said judgment which is the subject matter of appeal. Which is the subject matter of challenge in this appeal. Para, I have heard Sri Mullah, learned counsel for the appellant. I have also heard Sri G. Goswami, learned standing counsel railways. Full stop. The records of the learned tribunal have also been requisitioned and have been perused. Full stop. Para. The Sri Mullah, the learned counsel for the appellant, has submitted that under that section 2(29) of the Railways Act 1989, I go to Claims Tribunal 8 defines passenger, and to come within the said definition, comma, such person needs to have a valid pass or a ticket. Full stop. He has also referred to section 55 of the said act on the aspect of prohibition against traveling without pass or ticket. Full stop. He submits that under the aforesaid provision, comma, it is not possible for any person either to enter the platform or board the train. Full stop. In any case, he submits that the witness number eight, no. Who is AW2?
AW2, my lord.
AW2.
My lord, AW2 is Dulal.
No, AW2.
Yes, my lord. AW2.
AW2, yes.
Yes. AW2 Dulal. Sri Dulal Chaudhary. This Dulal Chaudhary, my lord, accompanied the deceased to the railway.
Just a minute. কি করুন? কি করুন? AW2 had deposed that he had accompanied the deceased to the Naharkatia railway station and saw the deceased purchasing a railway ticket. For the 902 down passenger train. Full stop. It is submitted that the observation of the learned tribunal that AW2 is the brother of the deceased is not correct. Yes, Mr. Mola?
Yes.
He's not
No,
brother.
no, no, he's not brother.
No, tribunal to.
Wrongly held.
What's the- Um, The learned counsel accordingly submits that the burden of proof that the deceased was a bona fide passenger being duly discharged in accordance with law, comma, there was no reason to reject the claim made by the claimant appellant. Full stop, para. Sri Mola has also criticized the judgment wherein the learned tribunal has come to a finding that it is practically impossible for a passenger to fall down and being run over by the same train. Full stop. He submits that such presumption is without any materials on record and not liable to be accepted. Full stop. Para. In support of his submission, comma, the learned counsel for the appellant has referred to the following judgments. Number one, 2008 9 SSC 527 नाम लिखी लो बा. Number two, 2017 ACJ 2447 into Calcutta. Number three, 2004 ACJ 713. It was Andhra Pradesh. Full stop. In the the case of Prabhakaran Vijaya Kumar Supra has been cited to bring home the contention which paragraph of this thing? Of
yes.
Supreme Court?
Yes, my lord.
12.
11 and 12.
Bring home the contention that the concerned act is a beneficial piece of legislation and therefore a liberal and wider interpretation is to be given. Full stop. Para. In the case of Bandana Mishra, comma, the Honorable Calcutta High Court had made certain observations on the applicability of the personal knowledge of the tribunal adjudicating a lease. Para. In the case of Agam Santham Manetu AP, it has been the aspect of the burden of proof upon the railways to prove that the deceased was a ticketless passenger has been highlighted. Full stop. Para. The learned counsel accordingly submits that the rejection is not sustainable in law and accordingly is required to be interfered with. Full stop. Para. Per contra, comma, Sri Goswami, the learned standing counsel railways has submitted that the deceased was not a bona fide passenger and there are no materials on record to come to a conclusion regarding the assertion made by the claimant that the deceased was a bona fide passenger. Full stop. He submits that the only evidence on record was a statement made by made by the witness AW2 that he saw the deceased purchasing a ticket. Full stop. He has, however, submitted that it reveals from the judgment, impugned judgment, that he was not aware as to the fare, FARE, paid by the deceased. Full stop. It is also pointed out that in the cross-examination, the said AW2 admitted that he was a relative of the deceased. Full stop. Para, Sri Goswami, the learned counsel, learned standing counsel, has also submitted that the claim was upon an assertion that the death was caused by the accident in which the deceased was run over by the concerned train. Full stop. He submits that it is practically impossible for a passenger to fall down from the same train, fall down and being run over by the same train. And this fact and this issue was considered by the learned tribunal. Full stop. It is submitted that the claimant had failed to discharge their burden and no inquest report was produced. Full stop. He has also submitted that no ticket was produced to claim that the deceased was a bona fide passenger. Full stop. Para. 3. Goswami has relied upon the case of Union of India versus Reena Devi, reported in 2019, 3 SCC 572 to 572, and to buttress his submission regarding the burden of proof. Full stop. In paragraph 17.2 of the judgment, which is upon the aspect of burden of proof when a body is found on the railway premises along with the definition of passenger, the following has been laid down. 17.2, quote, para. The learned standing counsel accordingly submits that no error has been committed by the learned tribunal, and accordingly the instant appeal is liable to be dismissed. Full stop. Para. The rival submissions have been duly considered and the materials placed before this court, including the LCR, have been carefully perused. Para. The claim is on the deaths of one Abhajit Chaudhary made by his father. Full stop. To sustain a claim before a railway claims tribunal, it is mandatory to prove, at least prima facie, that the deceased was a bona fide passenger. Full stop. Towards discharge of the said burden, evidence was adduced by AW2, who had stated that he saw the deceased purchasing one ticket and boarding the 902 down passenger train at Nahorkatia railway station. Full stop. The ticket as such has not been produced. Full stop. In a given case, comma, it may not be possible to retrieve a ticket more so in a death case. Full stop. However, it is required to see, it is required to examine as to whether the said burden was discharged with regard to the aspect of the deceased being a bona fide passenger. Full stop. The said AW2 in his cross-examination had admitted that he was related to the deceased. Full stop. However, that aspect will not make his evidence less credential if he otherwise meets the other requirements. Full stop. The said deposition has to be balanced with the other materials. Full stop. In the instant case, comma, there is a specific report whereby a specific report R1, a specific report marked as R1, as per which, comma, no ticket was issued on that particular date from Nahorkatia to Borhat, which was claimed claimed on behalf of the appellant claimant. Full stop. In view of such rebuttal evidence, which was not contested, comma, it is difficult to come to a conclusion, a concrete conclusion regarding the aspect of the deceased being a bona fide passenger in favor of the claimant. Full stop. Therefore, comma, therefore, comma, this court is required to look into the other materials on record. Full stop. Para. The case projected is that the deceased had fell down from the running train and was run over by the said train. Full stop. The learned tribunal has come to a conclusion that such a claim was not practically possible, as a passenger who claims to have fallen down from a running train cannot be run over by the same train. Full stop. The tribunal has also discussed that the running over can be possible only by another train, which is not the facts of the present case. Full stop. Though the personal knowledge of the adjudicator may not be the conclusive proof to come to a definite finding, comma, such a view is not a totally unreasonable or impossible view. Full stop. In the instant case, comma, what intrigues this court is that there is not even an inquest report which was proved or produced by the claimant. Full stop. So far as the post-mortem report is concerned, comma, this court may accept that the same was not available as the family members had requested not to have a post-mortem done. Full stop. However, since since GRPS case was registered in this case being GRPS number 348, comma, the production and proving of the inquest report was necessary to come to any conclusion which would have been a factor for consideration if the version projected by the claimant was bona fide and acceptable. Full stop. An accident by the involvement of a railway, involvement of a train per se will not entail payment of compensation, and it is only when the conditions are fulfilled under the Act and the settled principles of law that such claims can be considered. Full stop. In the instant case, comma, the aspect of the deceased being a bona fide passenger was itself not proved in accordance with law, which is coupled with the fact that the claim that the deceased was a bona fide passenger who had succumbed to his injuries being run over does not appear to be an acceptable and believable projection. Full stop. Para. The tribunal being seized with the facts and circumstances and the evidence on record had come to a conclusion, and unless such conclusion is prima facie against the materials on record or perverse, comma, this court, being an appellate court, may not interfere such findings in a routine manner. Full stop. The appeal accordingly stands dismissed. Send back these records.
Mark.
Decision के ऊपर होता है. Yes.
I didn't really.
Not to be. May it please your lordship.
Yes.
My lord, this division is, my lord, preferred by the newly implemented party. I was not a party in the main suit, my lord. The plaintiff filed a application for,
Suit for? The petitioners are newly implemented.
newly implemented, my lord. Suit for declaration, confirmation of possession and permanent injunction.
For declaration.
Declaration, confirmation and possession.
Declaration of right,
confirmation of possession and permanent injunction,
declaration of right to interest.
my lord. So that suit was filed, and my lord,
And then confirmation of position
confirmation of possession
and
and permanent injunction. Permanent injunction. Very important.
okay, then
Then, my lord,
we are not a party in the suit.
I am not a party. That plaintiff filed 1 to 4, respond number 1 to 4, file a application for amend the writ petition. Amend the, my lord, suit. Plaintiff, my lord.
1 to 4 are the plaintiff.
My plaintiff.
By respondents, 1 to 4.
No, that yes, respond here, respondent. Yes, correct.
Respondent was 1 to 4 are the plaintiffs in the suit.
My lord.
Okay.
A petition under order 6, rule 17, related section 151.
They filed the petition for amendment.
Amendment of the petition.
Amendment of the plaint.
Amendment of the plain, my lord.
Yes.
Amendment of the plain. Page
They
63,
filed order 6 rule 17 petition.
my lord.
Okay.
Order 6, rule 7.
Okay.
Then all right, my lord. Now, what happened? Then, my lord, in that case, my lord, page 63 is the petition filed for amendment, and page 71 is the reply filed by the defendant, my lord. Respond number 5 to 7. Stating that the land which was described in the, my lord,
They filed reply.
reply, my lord.
I find. Defendant find.
Yes, they
Yes, sir.
yes, your R27 are the defendants.
Defendant.
You had filed reply to the amendment.
They are contesting that it is not, amendment is not
Oh,
required because land which was described by the plaintiff, my lord,
Yes,
that is
yes.
said to be different land.
uh,
Although it is a DAG number and pata number same, but it's a different.
response. Okay, reply. Object, you file objection to the amendment. Okay. Thereafter,
Thereafter, my lord, amendment allowed, and not only that, my lord, also add the party. That I was added the party. So now I before your lordship,
page.
page 77 is the impugn, 79 is the impugn order. So, my lord, order 1, rule 10, 2, petition was not filed. To party to add, my lord, when the party has to add, my lord, but that means, my lord, without hearing me anything, my lord, it was my land was also, my lord, that is, my lord, incorporated in the plain. And also, my lord, I was added as a party. There is no petition under order 1, rule 10, 2.
37, 39, 22. Order dated 39/20/22.
Yes, my lord. So then I came before this honorable court against that order, and this order was stayed. Although proceeding was not stayed, this order was stayed.
Just a minute. This order had also added you as party.
I gave my part.
Amendment was allowed.
Amendment was allowed also at the party. While issuing notice,
Allowed.
then only I came to know.
But the court can so moto add parties.
Yes, that can be, my lord. But with the amendment also without, but when, my lord, already the order was passed, I cannot hesitate the matter, my lord. My lord, my simple submission before your lordship, my lord. Let them, my lord, yes, because with the court can, but
Yes.
without any application.
Yes.
That has to be, my lord, if the, on the pair of, my lord, party, pair of the, my lord, plaintiff, then has to be, my lord, order 1, rule 10 has to be filed, my lord.
Yes.
But that is not there.
No, they have not filed for impleading. Court on its own motion can implead.
My lord, dear lordship, kindly see,
Order one is very clear.
page 63, your lordship, kindly see, that petition, my lord.
Now, Mr. Mohanto, let us go to the extreme.
my lord,
Let us go to the extreme case that there was no prayer for impleadment.
my lord. No prayer for adding party,
No, the impleadment,
implement, yes,
no prayer for impleadment, only the prayer is for amendment.
my lord,
So the court had amended, but at the same time has also impleaded parties.
my lord.
Now is the court powerless to implead parties?
The court is totally not powerless, my lord. That is true, my lord.
Yes.
Court can even show moto, my lord, that order one. Before that, my lord, at least notice to speak to me, my lord.
No. If we exercise so moto
No,
power,
when my lord they were disputed, when my lord the defendant disputed the land which was stated by the plaintiff, my lord, that is totally different land.
no, how can you object at this stage? You have been given an opportunity of hearing, you have been made it parties. Because the court thinks that your impleadment would
No,
be-
amendment of the pleading also allowed, my lord. Amendment of the pleading, my lord, incorporated pairs, my lord,
no,
for setting aside the sale deed. That is also allowed, my lord, without hearing me, my lord.
no, but you are not even a party in the suit. You get all your chance to file your written statement in the amended
Correct, my
petition.
lord. Definitely, my lord. But when, my lord, the defendant clearly pleaded that land which was described by the plaintiff, that is not the land, my lord, which was, my lord, involved in the suit, my lord. So my submission before your lordship, at least, my lord, let this order may be passed. I have no objection, but in presence of me, are hearing me, my lord.
No, where is the scope of hearing you?
No, my lord, when
When
there
the court so moto exercise the power under order 1 rule 10-2.
court not so much to exercise.
No, rule 10-2.
Rule
Rule 10-2 come to 10-2.
10
Court
to, my
is
lord.
like
So yes,
of that
10 to, my lord, court has a power.
May at any stage of the proceeding, either upon or without the application of either party.
Exactly, my lord,
Now they have impleaded you.
my lord.
You contest the case.
No, my lord, when, yes, I will contest, my lord, because my
And just imagine, just contemplate a situation that the suit, the plaint which has been amended,
my lord,
that was also originally presented.
my lord,
Now the amendment has been sought, they had objected, but still amendment has been granted.
done,
Amendment done. Now you are in a position of a defendant
my lord.
who would be facing a fresh amended suit, plaint. You file a written statement.
No, I will file because there is a stay order, my lord. In my land, my lord, that will be, there is a stay order passed by lord.
That stay order will continue.
No, this or stay order, I am not talking about this stay order. In the order injunction order passed by the original suit. Because when land is itself is not, my lord, covered by the suit land, my lord, a new case has been projected, my lord. And since it is allowed, my lord, I have to wait for till end of the case, my lord.
No, on the powers, perhaps you have a limited scope, but on facts, that's a different matter.
No,
If you
when,
say-
when it is
If you
objected by-
contend,
No.
that you are not a
My
necessary
submission
party.
before your lordship, when defendant, my lord, file a objection, that's sitting there, this is not a land, my lord, which was, my lord, to the suit land. So that, my lord, in that point of time, at least I may be allowed to
No,
hurt,
they have not come. They are not aggrieved.
my lord. No, they have objected in land
Objected,
court.
they can file, they can be. They
No,
can
my
come
lord, why if my lord, we see my land is not under the litigation, but now is.
No, Mr. Mahanta, even if you entertain your matter, your contention or your submission has to be limited only to the aspect of adding at parties. You cannot make any submission and amendment. You are not even a party there. It's up to Mr. Bhattacharya to either challenge or accept. He has accepted. So far as amendment is concerned,
My lord,
amendment you cannot have any say now.
no,
can
amendment, my lord,
definitely challenge
amendment, by way of amendment, my land has been incorporated. My land has been incorporated. So my lord is a free from everything. Then how, my lord,
Now
you
you know what to do. You can challenge this independently.
my lord, it
Now
will be-
here, your challenge would best be within the circles of adding you as a party. If you think that you are not a necessary party, and if your land is affected, adding you as a party, we do not think that there is an illegal order. In fact, that order will be an opportunity to persuade the court.
No, my
Otherwise,
lord,
your lands are affected.
At least, my lord, before that, my lord, I should have given the time to my lord defend that this is not the land, my lord, which was his projected.
Now,
he filed a suit. Suppose,
now, if an application is filed for adding a party, issuing notice, that is okay. If there was not even an application for adding a party, in the amendment application, court exercises powers under order 1 rule 10-2.
my lord,
court has the power to strike off or add any parties at any stage.
my lord.
Now, before
That
adding
can be, my lord,
party,
that is.
before
absolutely
adding
true.
party,
Yes.
that will not require giving you a hearing. No, I want to add a party. What do you have to say? No.
No,
not
then,
that.
my lord, what remedy falls on me, my lord, because your lordship kindly suppose in,
So what prejudice have been caused to you?
because my land is in, my lord, another litigation, my lord, which is not the land, my lord.
You show cause before the court that this land is not, cannot be a part of this suit.
No, that already, my lord, they have, I have to wait till the end of the suit, my lord.
Where is the injunction?
My lord, injunction order, my lord.
Where is the injunction? They have only amended the application, the plain.
No, already, earlier injunction order is there, my.
Earlier injunction will it cover this amended after amendment?
No, my lord, definitely, my lord, now I cannot.
No,
construct-
suppose there is an injunction for
Right.
A land A, land under Schedule A. By amendment, the suit land is,
No, as soon as, my lord, I entered in the place as a defendant, my lord, I cannot do anything, my lord. That is also, my lord, my scope is, my lord, limited. Because I cannot construct my
where is that part of the, where is the injunction?
injunction, my. Injunction order, I have not enacted, my lord, but it is with me, my lord, 35%.
Where is the implement part?
Part of the order,
Yes.
my lord. Para 9, page 87, my lord.
87,
87, para 9, my lord.
yes. Yes. Yes, where?
In consideration of the reasonable grounds shown by the plaintiff, the pair seeking amendment is allowed, and that the plaintiff is allowed to be amended as a part of the proposed amendment and amended above this order. Dismissed. Proposed amendment, my lord, in petition, my lord. Proposed amendment, my lord, that is page 63, my lord. Para 67,
60?
page 63. Page 67, my.
Yes.
Para 18A be added as follows. That during the pendency of the associate with the defendant, Hashim Ali has sold the first 4.7 lakhs land regarding sale deed number so having it registered office so Assam Doti Director Mr. Anupam Deka on consideration of 1,74,000. That plaintiff came to know about the registered sale deed on 18/9/2021.
Where is the implement?
My lord,
Where is the implement?
my lord. No, yes, my lord. See, that the defendant Hassan Ali has illegally executed the appropriate sale deed for Kolkata 9 lakhs land for which the necessary to impede the purchaser SRD in the said suit, and also it necessary to claim relief and cancellation of a registered sale deed. That is going to say. So that is, my lord, in para 8, in that here on to 8, my lord, and impede the purchaser SRD. And in one also, 67 para 1 also, in heading of the defendant number 3A, in the heading main defendant number 3A, MS SRD Limited Private Limited Company incorporated under Company X, so. Proposed amendment.
Where page?
Page, my lord, start from 66, my lord. Proposed amendment, has a lot got it. The very last line, my lord. Page 66, my lord. Proposed amendment. Then, my lord, page 67. A1, in the heading main defendant, 3(1)A. Now it became a main defendant, my lord.
Now your rights should be affected by this suit, by the adjudication of the suit. You have been given a hearing and they are also praying for cancellation of sale deed
My lord.
1760 of 2020,
But
which is in your favor.
yes, my lord, is my.
Now you have been given a chance that before we cancel this sale deed, you'll
No,
be
that-
given.
That I have to contest the suit, my lord.
Yes.
If, my lord, before that, if I should have heard, my lord, I have clearly mentioned that, my lord, that land which was My lord, he suppose he purchased the land, the nearby land, my lord, is mine.
You are
So
not,
he also included that land also, my lord.
you are not convinced.
Then, my lord, everything in my, I have included in that suit, my lord, which is not, my lord, part of the suit land, main suit land, my lord. So that's why I'm submitting, my lord, that at least, my lord, let them pass this order, but after hearing me, my lord. Then your lordship kindly, my lord, if your lordship, my lord, not entered in-
8 and 9 are not complete. They are, it is held to be complete. Held to be complete.
my lord.
Let us see who are the parties here.
8 and 9.
Who was the plaintiff there?
1 to 4, my lord.
You are for? Who's for 1 to 4?
Plaintiff, my.
No, who is appearing? Where is he? They have been served. They are the,
Sir, my lord. They are the,
they are the main,
they are the plaintiff, my lord, yes.
they would be the contesting parties.
Contesting.
Let us give another chance to Mr. Sohoria. I think he comes from Mongoldoy.
My lord, in earlier occasion also not coming to the court, my lord, they are not.
Okay, we'll make an observation.
My-
Third, Sri T.J. Mahanta Leonard Senior Counsel for the petitioner, assisted by Ms. P. Bhattacharya. None has appeared for the respondent numbers 1, 3, and 4. Whereas Sri A. Bhattacharya Learned Counsel has appeared for the respondent numbers 5 and 7. 5, 6, and 7. Full stop. The respondent number 2 was struck off earlier. Full stop. Para. On the earlier occasion also, that is 10/6/2024, the contesting respondent was 1, 3, and 4 were unrepresented. Full stop. The cause list has reflected the name of the counsel for the said respondents. Full stop. Para. Be that as it may, let a final opportunity be granted to the respondent numbers 1, 3, and 7 to be represented. Full stop. List on Friday?
My lord.
List on Friday, Friday, date 2, it is however made clear that in case there is further non-representation, this court would go ahead
My-
with the matter. Full stop. Is there an interim order?
Yes, indeed, my lord. There is
Interim
the
order
order.
passed earlier
Welcome.
to continue till the next date of listing.
Sorry, you.
We'll have it on Friday.
My lord.
I think 4 and 5.
Lordship, we have,
Yes.
we have filed appeal against rejection or application protecting the ex parte interim injunction order. And we have also filed a CRP challenging the order of the Honorable Session Judge on the ground that for hearing the injunction petition, they are calling for the record of lawsuit valuation certificate and the sale permission certificate and everything. Fact of the case is, Lordship, I am the owner of a shop.
Mr. Kyle for
I'm for 1, 2, and 3.
contesting respondents.
So- No, we are the plaintiff for that fact.
Yes, you are a contesting respondent here. Okay. Okay. Yes, can we go ahead?
Lordship. Yes, sir. Fact of the case is, Lordship, we are the owner of a shop at Dibrugarh. Shop was gutted by fire.
Okay, let us note down some facts.
Lordship, that is well.
Yes.
Shop was gutted by fire.
Just a minute, please. You have one CRP and you have one FAO
Lordship.
by the same party.
The same party, FAO, there is a delay of 59 days. Delay.
Delay is yet to be condoned.
Delay it will come.
So we condone the delay
Yes, sir. Delay.
and both will come up for analogous hearing. We pass orders in the IA and have both the matters on a fixed date? Okay,
If I have a small prayer in it, so that dispute between the family members. They are the brothers and the two brothers. And now, Lord, if there is a dispute, and Lord, may please to see how they'll be, Lord, may please write down some dates. They are very important.
now we are adjudicating only, we are passing orders only in the delay condemnation. Are you objecting to the delay
No, Lord,
condemnation?
I'm not objecting, but Lord, even CRP.
CRP are not passing any orders, we are not taking it up.
No, Lord, in this case, what happened? There is an interim order
Okay,
whereby the trial court was directed to not to proceed with the case, where injunction was granted. In terms of that order, Lord, they have completed the consent.
they are going ahead.
Even a major portion of construction has been completed. And please, we are filing application, but the Rana trial court is not impacted. What if this is the order after the Rana trial? And Lord, if I
You
photograph-
maintain status quo, Mr. Goswami?
Yes, Lord. Lord, if I photograph with me, what people will be surprised to see.
Which place?
Dibrugarh
Dibrugarh
in town.
Let us go to Dibrugarh.
Lordship. And Lordship, in the meantime, I'm.
Why do you believe photographs?
Because Lordship dates are there, and Lordship may, if required, commission may be. Sorry, whether-
Mr. Goswami, yes?
Look, fact of the case is like this. We have a shop at Dibrugarh town.
We'll have it, today is we'll have it day after tomorrow. We'll condone the delay today,
Sure.
day after tomorrow.
Better.
Lordship,
I think that, let the delay be condoned, let the matter be ripe for consideration. IA is 1347.
Okay. 154. 68 days delay.
Heard Sri S.K. Goswami, learned counsel for the applicant who by means of this application filed under section 5 of the Limitation Act 1963 has prayed for condonation of delay of 68 days in preferring the appeal against the order dated 13/10/2023 of the learned civil judge, senior division, Dibrugarh, in J case number 170 of 2023, arising out of TS 58 of 2023. Full stop. The learned counsel has drawn the attention of this court to the averments made in paragraphs 10, 11, and 12 of the petition and has submitted that there were sufficient grounds and reasons for which the present revision could not be presented in time. Full stop. Para. Sri Kyle, the learned counsel for the contesting respondent numbers 1 to 3 has submitted that the reasons shown are not sufficient. Full stop. However, he submits that on principle, comma, he would contest the case on merits rather than on the aspect of limitation. Full stop. Para. In adjudicating an application praying for condonation of delay, comma, this court is to see that substantial justice is to be preferred over technicalities. Full stop. This, however, does not mean that unexplained or inordinate delay are to be condoned in a routine manner. Full stop. Para. In the instant case, comma, this court has noticed the reasons assigned in the paragraphs mentioned above. Full stop. Considering the same and also the fact that the delay is not an inordinate one, comma, the same is condoned. Full stop. Let the this is not in the revision. This is in
Appeal.
appeal.
FAO.
Let the FAO. It's already numbered.
Not now. State number is here, 3568.
Let the FAO be registered and the same be listed along with CRP IU 118 of 2024 on
Thursday.
Thursday, is okay? Day after tomorrow. তুমি উপরের দিকে কইছি in preferring the revision নয় in preferring the appeal. Okay.
The interim order passed in revision to continue.
এটাই অর্ডার দিব নাকি রিভিশন লিখে লিখব লিস্ট along with the connected FAO wherein the delay in filing the said appeal has been condoned today. কি বলে আরম্ভ করব লিস্ট along with the this of today no the list along with the connected FAO on Thursday, huh? The delay in preferring the said appeal has been condoned vide an order passed today in IS Civil 1347/2024.
Copy of
The interim order passed earlier
CRP.
to continue. CRP only. To continue till the next date of listing.
Lordship, copy of appeal may be.
I can give 2 days.
Yes. এখানে ঘুরে
Like,
It is your lordship. Lordship, your service is complete, but none appears, lordship. On the last date also, that order was passed, lordship. And this is based on our appeal is based on a settled proposition of law, lordship, because the deceased himself was the owner of the vehicle. So MB Act does not cover liability. Only option before the claimant is that they can file a petition before the insurance company and they will get that OD claim 2 lakhs of it. So I have the judgment. I'll read the judgment first, lordship. But no one is appearing.
Doesn't matter,
Yes.
last occasion it was made clear.
Yes, lordship.
This appeal is from a tribunal's award.
Yes, lordship.
What was,
Judgment was passed on 1/4/2011. lordship.
just a minute, please. Yes, judgment is 1/4/2011.
Yes, lordship.
What was that
The-
case?
Death case, lordship. The claim, I'll read, lordship.
That case?
Death case.
Who passed away?
The husband, lordship, Raja Nandi. Husband of Dipali Gohai Nandi and father of Vishal Gohai.
Claimants are his widow and son.
Yes, lord.
Okay.
The claimants Srimati Dipali Gohai Nandi and Sri Vishal Gohai Nandi being the wife and son respectively of late Raja Nandi, who died in a motor accident on 22/9/08 at Pub Banipur under Dibrugarh Police Station in the district of Dibrugarh, filed this claim case for compensation of rupees 23,15,000. According to them, on the aforesaid date, deceased Raja Nandi, along with 2 others, was proceeding towards Tinsukia from Dibrugarh, driving the Maruti van bearing registration number so and so. Suddenly, at Pub Banipur 1709 bus bearing registration number so and so being driven rashly and negligently by its driver dashed against the Maruti van from the front side. As a result, Raja Nandi and one of the occupants, Debohit Borua, died on the spot and other occupant, Gobind Sharma, sustained grievous injuries. The Maruti van also got badly damaged. A case to that effect was registered by Dibrugarh PS case number 45508 under section 279/338/20 304A/427 IPC. At the time of his death, Raja Nandi was aged 38 years and his earning was rupees 15,000 per month for doing service at MS Margarita Auto. Due to the death of Raja Nandi, the claimant suffered mental shock and lost love and affection and expectation of future happy life. The driver, owner, and insurer of the offending bus and insurer of the Maruti van have been implicated as opposite parties in this case. They filed their separate written statement. The opposite party number 3, New India Insurance Company, insurer of the offending bus, pleaded that claimants have to prove monthly income of the deceased. They stated that since two vehicles are involved in the accident, quantum of compensation of both the vehicles is required to be ascertained. The opposite party number 1, owner, and opposite party number 2, driver of the offending bus, by filing their separate written statements, stated that if any liability is found upon adjudication against them, then also they are not liable to pay any compensation as the offending vehicle was driven at the relevant time with valid insurance policy and valid driving license. The insurer of the Maruti van, opposite party number 4, National Insurance Company, in their written statement held that they have been falsely implicated as the deceased was not a third party. Upon this ever pleading, following issues were framed: whether a motor vehicle accident took place on 22/9/08 involving vehicle number so and so Maruti van, whether the deceased died in the accident. 3. Is the claimant entitled to compensation? If so, to what extent and from whom? Additional issue 1. Whether the case is maintainable in its present form, and if not, whether a petition filed under Section 163A MB Act can be treated as petition filed under Section 144 MB Act. The claimants examined two witnesses, including claimant number 1, wife of the deceased, and proved some documents. The opposite parties did not adduce any evidence. I have heard the learned counsel. To determine the above points, I have carefully gone through the entire evidence, both oral and documented. Now I proceed to decide the issue. For the sake of convenience of discussion and to avoid repetition, all the issues are taken up together for discussion. Decision on the issues with discussion. During hearing, learned advocate Sri S.K. Agarwal, appearing for the claimant, submitted that in view of the decision of Honorable Apex Court in Sarla Verma case, in spite of the deceased was earning more than rupees 40,000 per annum, the claimants can maintain a petition under Section 163A MB Act and pray for compensation on the basis of structured formula. He further submitted that the claimants clearly proved that the deceased was an income tax payee and he was earning more than 15,000 per month and he was aged about 38 years. Therefore, in computing compensation, 15 multiplier is required to be applied, though the claimants prayed for using 18 multiplier. Last claim of his submission that since there was involvement of two vehicles and both the vehicles are duly insured, therefore both the insurers are liable to pay compensation. Countering the contention raised by Sri Agarwal, Sri G. Chakrabarti, learned counsel appearing for insurer of the 709 bus, opposite party number 3, categorically submitted that at the relevant time, the deceased was an unemployed person. He also contended that the salary certificate, Exhibit 4, is a procured one. The employer CW2 failed to produce records of books of accounts of his firm wherein salary paid to the deceased has been recorded. On the other hand, the opposite party number 4, the insurer of the Maruti van, submitted that the accident took place for the fault on the part of 709 bus, and the claimants have not paid any compensation from the opposite party number 4.
11 you can skip, 11 you can skip, 12 you can skip.
Yes, but
Regarding the,
income and all.
no, regarding the petition under 163 being maintainable, that you can leave. That is not your, I think.
No,
ground
ours
of-
is only this part, Lordship, that he is not a third party as against his own. That is our contention.
What about the insurance company of the offending truck?
They were served, Lordship. I think they have paid because, Lordship, the direction was for payment by 3 and 4
In the by the tribunal.
in equal share, Lordship. Lordship will find the order at page 13 of my memo. Total amount calculated was 14,49,500 with 6% interest.
What was the nature of the policy? with the Maruti vehicle.
Yes, Lordship. Policy I have also annexed here, Lordship. It was a package policy, Lordship, and he had paid premium for his own compulsory PA cover, 100 rupees was paid.
Then,
Then Lordship, 2 lakh rupees he will get from the insurance company and not under the MBR. That is the settlement. I have made a small write-up. on
when
that.
was your accident? Accident was in the year 2008.
Yes, Lordship.
2008, the same condition existed that in case of a claim
Huh.
for self, the
Huh.
maximum entertainment is 2 lakhs.
Yes, because of the policy, Lordship. That is one judgment I'm giving of Dhanraj. Dhanraj is of 2004, Lordship. Then 2007 judgment, Oriental Jumma Saha. And Sunita Rathi is of 98.
Where is the discussion in this judgment regarding that aspect?
In Dhanraj, Lordship?
No. In the judgment passed by the learned tribunal.
No, tribunal has not. Tribunal has just said about contributory negligence. Hence, Lordship, Jumma Saha's case, if the deceased himself was responsible for the accident, then also they do not get. So, a court has, for paragraph 14, court has only taken contributory negligence of both the way. That way, it has come to that finding.
No, nobody has appeared for the insurance company of the bus
No, here no. There they appeared, but here notice was served.
in, which one? Which
Uh,
insurance company?
New India. They are respondent number 5 in our.
Yes, what are the
And
issues?
what the court could have done is, since the bus was responsible, the court could have directed the other insurance company to pay the entire amount. That would have been another year. But the court held that it was contributed in it. If the deceased himself contributed towards the accident, then how come Jumma Saha says that he does not get the.
What is the subtle law that the owner himself driving the? Dhanraj, which paragraph?
Dhanraj Lordship, paragraph 9, because it is relying on Sunita Rathi. Sunita Rathi is of earlier time, but 9 paragraph Lordship. In the case of Oriental Insurance Company Limited, Dhanraj Lordship, it was for his injuries. It was not a death case. Versus Sunita Rathi and others, it has been held that the liability of an insurance company is only for the purpose of indemnifying the insured against liabilities incurred towards third party or in respect of damages of property. Thus, where the insured, that is an owner of the vehicle, had no liability to a third party, the insurance company has no liability also. So, Lordship, when what was discussed there was when the owner himself, he does not incur that liability to other third party. So naturally, the insurance company cannot, does not have to pay. And in paragraph 10, it says, Lordship, in this case, it has not been shown that the policy cover any risk for injury to the owner himself. But there is slightly different. In our case, that PA cover is given. That's why in my small, write-up, Lordship, in the paragraph 2, I have mentioned that since he had that PA cover, he will get that 2 lakhs of it. And our High Court judgment also I have given, Lordship. In these cases, in Umakanti Convert, there was a scooter and he stepped in.
So how does one protect himself? A owner who buys a vehicle,
Yes.
his vehicle meets with an accident not because of the involvement of any other vehicle.
That's why that 2 lakh. Now it is enhanced to 15 lakh because this question came up that to a third party, we are paying crores of rupees, but to the owner himself who is paying the premium, such less amount is there. So now the cover is given till 15 lakhs to the owner. But here, since the bus was involved, the
Now, suppose a vehicle meets with an untoward accident involving no other vehicle.
Hmm.
It dashes with because of some mechanical failure, dashes with some object, not a vehicle, maybe a tree or any stationary object. And the owner who was driving the vehicle, he passes away. Then how does the owner, in contemplation of such an eventuality, how does he protect himself by insurance?
that is the 2 lakh of rupees,
Only 2 lakhs.
only 2 lakhs. Now it is 15 lakhs from, I think, from 2020 or something.
There is no manner he can protect himself by paying higher premium or whatever.
Lordship,
It is ultimately an accident, death out of an accident.
yes. Premium is always ideally on the,
The law to indemnify is okay, that if you are required to pay to any party, then you will be indemnified by the law of insurance.
Yes.
Now, in a case where the owner is the victim,
Hmm.
not because of involvement of anyone else, then by paying what kind of premium he can protect himself?
that is the premium that in this case also the owner has given PA cover, Lordship, 100 rupees that he paid. And that will cover in a four-wheeler Lordship 2 lakhs, and in a scooter or two-wheeler it
No,
will be
that is
1
the
lakh.
2 lakhs is wholly inadequate. Suppose he was a businessman earning a handsome amount.
But his case is not maintainable under MB Act. Because he is not a third party as against his own vehicle. Lordship, he is the first party, insurance in the second party, and the third party is the person whom he hits, or because of his vehicle someone is killed or injured. So in his case will not be maintainable under the MB Act. That is the law.
That means you should not ride your own vehicle.
That's true, Lordship.
It
And
becomes
even if I drive, I should hit a third vehicle, second vehicle, so that from that vehicle against
You
that
cannot
vehicle.
drive, you cannot ride.
Hmm.
Owner means owner, whether you are driving or you are just as a occupant in the
Correct.
vehicle.
Correct. That is why this question came up again and again, because this owner has in fact paid premium. And suppose, Lordship, in this case, had it been a third party, had he hit a third party, that person's income, everything would have been calculated, and he might get crores of rupees as compensation.
There would be some explanation in some case laws.
No, Lordship,
cannot,
these are the case laws.
This cannot be for a proposition which is not reasonable at all.
But Lordship, that is the settled proposition. Lordship. In our High Court only, Lordship, in Umakanti Convert case, it was the driver stepped into the shoes of the owner of the vehicle. Court directed that I did the same case. Lordship. I was the appellant there also. The court
Now,
directed
this
that,
is the case where you are referring.
yes,
Dhanraj is a case of injury.
yes.
Let us take an extreme case of death.
Lordship, Jumma Saha, for his own fault, he put the second case I have given, Lordship. 2007 9 SCC 260 Oriental Insurance versus Jumma Saha.
Dhanraj is 2004 8 SCC
Yes, 553.
553 paragraph.
Relevant paragraph, Lordship, 9 and 10, Lordship can take. In Jumma Saha, Lordship, paragraph 6. The deceased,
Zuma Saha is 2007.
yes, 9 SCC 263.
Para 7. Para 6.
Para 6 you must, and 7 and 8 also, because there also Dhanraj is referred to.
Para 6 Jumasa.
The deceased was the owner of the vehicle for the reasons stated in the claim petition or otherwise. He himself was to be blamed for the accident. The accident did not involve motor vehicle other than the one which actually is spelling mistake, he was driving. The question which arises,
Just a minute. The additional premium was paid in this case,
yes,
our case.
yes, 100 rupees was paid, so they get that amount. Otherwise, in some cases, if not paid, then I do not give this proposition that they had paid and they can claim it from the insurance.
What is the third case? Sunita?
That is Sunita Rathi. In this case, regarding the policy lordship, basically,
Yes.
paragraph 3 lordship, it
19,
follows that the insurer cannot be held liable.
1998, 1 SCC.
1 SCC 365.
Sunita Rathi. Paragraph?
Paragraph 2 is the fact lordship, because here the policy was not the policy was taken after the accident. So 3, the court has discussed. It follows that the insurer cannot be held liable on the basis of above policy in the present case, and therefore the liability has to be of the owner. However, we find that the High Court, without assigning any, has simply assumed that the owner of the vehicle was not liable and the insurer alone was liable in the present case. This conclusion, in fact, this case is not totally to our point of issue law. The conclusion reached by the High Court is clearly erroneous. The liability of the insurer arises only when the liability of the insured
No,
has
this is
to
on the
be.
cover. Madam, this is not applicable. This is on the cover.
No, for
From
this,
which date?
from this part, I am submitting this case for this part, lordship.
Which part?
In paragraph 3, lordship,
Yes.
when the liability of the insured has to be upheld for the, the liability of the insurer arise only when the liability of insured has been upheld for the purpose of indemnifying the insured under the contract of insurance. There is thus a basic fallacy in the conclusion respect. This part, lordship, our liability, insurance company's liability comes only when the owner is liable, insured is liable. Here in our present case, lordship, since insured himself was driving the vehicle, he is not liable to any third party.
The other cases, this is on the cover. There was no cover.
And the second part of my
What is this Umakanti?
Umakanti lordship, what happened here, the vehicle was taken by another person. He was driving the vehicle, and then it has come that it is, he has stepped into the shoes of the owner of the vehicle. And so the paragraph 10 and 11 lordship. It has admitted position that on the fateful day, the deceased was driving the vehicle on his, of his father, which was paragraph 10, Lordship, 10 and 11.
Yes,
It has admitted position that on the fateful day of the the deceased was driving the vehicle of his father, which was insured with the insurance company. And in view of the decision rendered referred above, he stepped into the shoes of the owner, and the insurer is not liable. Insurance company is not liable to indemnify the owner, who is not a third party. Accordingly, this court is constrained to hold that the award passed by the learned tribunal is bad in law and liable to be set aside. Accordingly, the award passed by the tribunal in MSC case number so and so is quashed and set aside. However, this part lost. However, the petitioner is at liberty to approach the insurance company for getting the amount given under the policy against the premium that was paid against the owner, which will cover about 1 lakh as per entitlement. The appellant insurance company will do the needful. So, on
The,
such approach by the claimant.
the son has also been deemed to be the owner.
Step, that is Ningamma Lordship. Ningamma, I haven't given Ningamma. That is stepping into, if someone drives the vehicle, he steps into the shoes, not only son. And Sadhana Lodh Lordship, there is another judgment, Sadhana Lodh, where the son is not considered a third party when he was driving the vehicle. In Umakanti, it is mentioned New India versus Sadhana Lodh and Ningamma versus United Lordship. At paragraph 6 of this judgment, Umakanti.
And the last one,
Last one, also our High Court Lordship, paragraph 4. I'll read the tip.
this is 2006
2006 3
GLR.
GLT or GLR, the numbers are different. GLT 379, GLR is 31.
Here which paragraph?
Paragraph 4, Lordship, I'll start with paragraph 4. The question, therefore, is whether an insurer can be made liable to pay compensation of the injuries sustained by the owner of a vehicle, particularly when the owner himself was driving the vehicle. The answer to this question can no longer be said to be in doubt or uncertain, for it is no longer res integra that the liability of an insurer is only to indemnify the insured against the liabilities which the insurer may incur towards a third person or in respect of damage to property. It is therefore clear that when the owner of a vehicle himself sustains injury, he cannot be said to have become liable to pay compensation to anyone. And since the owner in such a case incurs no liability, the insurer can also not be present with any liability. In such a case, it is really not material whether when the accident took place, the owner sustained injuries. The owner was himself driving the vehicle or someone else was driving the vehicle. The law in this regard has been succinctly laid down by the Apex Court in Dhanraj versus New India Insurance Company Limited and another, wherein the Apex Court has observed and held as follows. Thus, an insurance policy covers the liability incurred by the insured in respect of death or bodily injury to any person, including an owner of the vehicle or his authorized representative, carried in the vehicle, or damage to any property of a third party caused by or arising out of the use of the vehicle. Section 147 does not require an insurance company to assume risks or death or bodily injury to the owner of the vehicle. 9. In the case of Oriental Insurance Company Limited versus Sunita Rathi, it has been held that the liability of an insurance company is only for the purpose of indemnifying the insured against the liability incurred towards a third party, or in respect of damages or property. Thus, where the insured, that is an owner of the vehicle, has no liability to a third party, the insurance company has no liability also.
Yes.
Because of what has been pointed above, it is abundantly clear that the owner of the vehicle in the present case has not incurred any liability, and in view also of the fact that no premium was paid to the insurer for personal, this is the different part in our case, that he had paid that premium first. That may be cost to the owner of the insurer could not have been directed to pay compensation to the owner. In the result, so that is my humble submission, Lordship, that the appeal may be allowed, and if the claimants, they so desire, they can, as per Umakanti Confer, they can approach the insurance company, and that amount the insurance company. It will
No,
be.
but you were only aggrieved by the direction where half the
Yes.
amount
Yes,
has been settled upon you.
yes,
You said that your liability can at best be stretched to rupees 2 lakh.
2 lakh.
But the total amount, you have not made your submission. It is up to the national insurance. You are for whom?
We are national insurance,
Who is the other one?
New India.
New India knows appearing.
No, the service is complete.
Who normally appears?
Normally, Lordship, lots of Gosamida,
Mr. Goswami? Can you come?
Datta sir,
Here, New India is also a party.
it attempt
It's an old case, but
for a net. Ipatiko. I did.
no, there is no, panel kind of, but you normally appear on a case-to-case basis.
Yes, sir.
The arguments which have been advanced, and if we accept those, then even if you do not interfere with the total amount, the liability would come upon you. Upon you means upon the other insurance company. So their views, I think, would be required. But they have received notice and chosen not to appear. There is no obligation on our part to again require you to have, but for the interest of justice, maybe there may be some communication gap. You must have heard the proceedings.
I've heard just about the interpretation of.
Yes, the two vehicles are there. The deceased was driving one vehicle, and the total amount which has been arrived at was 14 lakhs odd has been divided into 50%. What madam is contending that since she is the insurance company of the vehicle which the deceased was driving, her share can at best be stretched to rupees 2 lakh. So if 7 lakhs is made 2 lakhs, your amount, your part, your share would go up. It was 14 lakhs odd.
The first funding, that funding of 50/50, that has to be challenged. If
No,
that is not challenged.
No, you are not, you have not challenged. The contributory part
of
has
their
attained
other
finality.
mechanism.
Contributory, now if they said that their limit of indemnifying is only to a particular amount, then since the contributory negligence part is not under challenge, the entire thing will, burden will come up to a maximum extent, except 2 lakhs maybe. So I think you may have something to say. You are a party here.
We can understand given to the company, I'll just tell them about.
You can make some communication. We are not passing any formal orders. You can note down the matter from madam, and
I'll give you a copy.
you can communicate. We can have it sometime when next Thursday. It's an old matter. Has
Just
anything?
before the vacation, Lordship, I may need to collect some.
Okay. This award is of which year?
2011 lot,
Uh,
Just before the vacation.
1411.
Is there any interim order here?
No, no, Lord.
You have paid.
No, no, no. Stay petition was there, it was not moved. Today I checked.
They have not gone for execution.
No, no.
And their part,
Their part, I think they have paid. I do not have that. That is not, maybe they have paid. Maybe in the LCR it might be mentioned. Because they have not filed any UNDA file.
who is 124?
Lordship. One, two are the claimants. 4 was striked out, Lordship, driver.
Who's 3?
3 is the owner. Owner of the other vehicle. Because for our vehicle, there is no driver and, because the owner himself was the driver. So the 3, 4 and 5 are of the other vehicle. Out of that 4 was striked out. Only 3 and 5 remain. 3, Lordship, was the
But last occasion, it said that if on the next date fixed, none appears for the respondents, means the respondent New India, the court shall pass appropriate orders. Okay, we give a chance, huh? Heard Miss R.D. Mazumdar, learned counsel for the appellant. While none has appeared for the respondents. Full stop. From the initial arguments advanced, from the initial submissions made by Ms. Mazumdar, it appears that it is the share of the appellant insurance company, namely the National Insurance Company Limited, which would be the issue for adjudication. First of the principal contention is that the deceased, being the owner of the vehicle, the insurance company of the said vehicle cannot be saddled with any liability other than the extent covered by personal accident,
by the policy.
by the policy. Full stop. Para. The insurance company of the other vehicle is also made party respondent number
5.
Insurance company of the other vehicle, namely New India,
The New India Assurance.
New India Assurance Company Limited has been arrayed as party respondent number 5. Full stop. The findings of contributory negligence is, however, not the subject matter of challenge. Full stop. Para.
Left.
It appears that the role of the other insurance company, namely New India Assurance Company Limited, would be of some significance. Full stop. Para. In view of the above, this court is of the opinion that another chance, another opportunity may be granted to the said insurance company. Full stop. Para. List on when?
Just we gotta make it. Just before the vacation.
List on
27.
list on 25th. 25th. You can
Yep.
make some notes from the court files. Or from madam, you can get a photocopy.
Highly obliged.
There was conclusively heard by your lordships on 1/8/2023 probably, my lord. Thereafter, the lordship had posted the matter for passing orders, but in the meantime, probably lordship got posted to some outline bench. So, look, this matter remained as it is. Now, what has happened in this case is that the respondent herein, my lord, he suffered certain injuries in a bomb blast in the Dimapur railway station. Based on those injuries,
When was it heard?
It was heard on 27, 2020. 20th July, 20.
Almost a year.
yes,
Thereafter it had come, but we have not passed. You are supposed to have some instructions.
that instruction was, he has got, my lord, the doctor is still alive, my lord.
That's
Well,
what-
we have to hear
I'll
it
just
again.
remind your lordship what has happened, my lord.
আমার নোট নাই নাকি এটা? নোট কেন না থাকিব? নোট তো থাকিব। বেলেগ ফাইল আছে নেকি আৰু কিবা? নাই ন? নোটছ আছে নেকি? নোটছ আছে? নাই ন? নোট তো আছিল।
Lordship may be able to remember if I just give the brief details of it.
Yes, will you? Yes, sir. Madam, have a seat. Let,
On 2nd of October 2004, there was a bomb blast in the Dimapur railway station at platform number 1. In that bomb blast,
second,
2nd of October, 02/10/2004.
তুমি আহিব পাৰা অলপ পিছত। At least 3টা বজাৰ আগত 20 মিনিটটো হ'ব। Bomb blast at Dimapur.
Dimapur railway station at platform number 1.
Okay.
The respondent here in Malot, he got injured. Based on those injuries, he filed a claim application before the Railway Claims Tribunal. And that application was decided on 12/1/2007. And he was granted a compensation of rupees 2 lakh.
12
12/1/2007.
judgment by
Yes.
the RCT.
Guwahati.
Guwahati.
Guwahati. He was granted a compensation of 2 lakh.
Okay.
Out of that, 1,20,000 was paid for injuries suffered under provisions of Part 3, serial number 27 of the rules. That is injury to his eye.
Under part?
Name the rule. This rule is called the Railway Accidents and Untoward Incidents Compensation Rules, 1990, and rupees 1,20,000 was paid on account of injury suffered on his eye.
Under schedule, you said schedule or something?
Serial number 27 of Schedule 3.
Of the railway accident and
Untoward Incidents Compensation Rules, 1990. I provided a copy of the rules to you last month earlier, which probably it's there in the file.
compensation rules of
1990. Can hand over the book.
নাই একো নাই ৰোড হেৰিও নাই কিবা দিছিলে মোৰ মনত আছে মোৰ
Like I had handed over the book to the court master, he got it, photocopied and returned it to me.
No, we remember making some notes. Notes are also not here.
Yeah, I can hand over the book.
No, we'll take a copy. No, even the notes of the court are not here.
Those are probably not.
Okay, then,
And the remaining 80,000 was paid for non-scheduled injuries, 10 number of non-scheduled injuries,
80,000.
80,000. 2 lakh is the total amount, 120 for serial number 27, and the remaining 80,000 for 10 numbers of non-scheduled injuries. This amount was paid to the respondent paid. After that, in the year 2008, based on a certificate issued by a doctor in Nagaland, Malot, the certificate is dated 8/9/2008.
8/9
2008. He filed a miscellaneous application
after
before,
1 year.
after 1 year. He filed a miscellaneous application before the RCT
On
claiming
8/9/2008, he filed, or that
the
certificate is
second
8/9.
application was filed on 14/7/2009.
Second application.
Second, miscellaneous application for enhancement of the compensation. He claimed further 2 lakh rupees on the ground that he has suffered permanent disability on both his ears.
Further 2 lakhs claimed.
Claimed on account of permanent disability suffered on both his ears.
Both his ears.
Both the years. He said he became deaf and deaf. He means that he became. Now, this application was decided on 27/8/2011.
Decided, held,
Decided,
held to be entitled.
held to be entitled under rule number sub-rule 4 of rule 3 of this rule. This rule is not at all applicable.
It was held to be, it was decided under order.
Sub-rule 4 of rule 3. If I may just read out sub-rule 4, doctor will get an idea why this is not applicable. May I read?
Yes, please.
When compensation has been paid for any injury which is less than the amount which would have been payable as compensation if the injured person had died, and the person subsequently died as a result of the injury, a further compensation equal to the difference between the amount payable for death and the already paid shall become payable. The enhanced compensation is payable only in case the person dies. Here the person is still alive. So that is why I say this provision in the which the enhanced compensation was granted is not applicable. Now, the second ground is that, my lord, the doctor who had issued the
Just
certificate,
a minute. Yes,
doctor who had issued the certificate, my lord,
yes.
that certificate itself was never proved before the tribunal. The doctor was never offered for cross-examination. So that was the main ground, and that aspect of the matter is recorded in the order that was passed by your lordship on 27/2003.
We'll,
So-
we'll check. You said that the certificate 8/9/2008 was not proved.
Not proved, and the doctor who had issued the certificate was never offered for cross-examination.
That is not proved. Certificate was not proved. It has been
Not
proved.
proved. Now, a learned counsel on the other side, Malus, she was asked to obtain instruction as to whether the doctor is still alive, so that if the matter is remanded back to the tribunal and a fresh decision can be arrived at.
No, first, that issue will come, definitely. But first, in absence of any other provision, if there are, whether 3/4 could have been applied.
So 3-4 could not have been implied
That is it. If 3-4 is goes out of the,
equation.
if 3-4's application is excluded, would there be, is there any other provision by which?
Probably there is, my lord. It's probably the
No, Mr. Sharma,
my lord.
we may, for the time being, let us accept what you have, how you have interpreted 3-4. That is only for death. Let us accept, but will it preclude any other accident, any other incident by which some other grievous injury, grievous eventuality or consequence happens subsequently? Will a victim be precluded?
No, not at all, my lord. There is some provision.
Then
Even-
by wrong quoting of 3-4, we may not,
Even lordship was of the
we are on the other
Yes,
aspect,
ma'am.
whether the basis of the enhanced claim, that which is a certificate, that not being proved, the doctor not having been examined, whether any enhancement could have been considered at all.
Yes, my lord, I should admit this fact that on the last occasion, also lordship was of the view that this ground which I have taken would be sort of hyper technical. So lordship was very reluctant to take cognizance
What
of
was the order, 20?
27/8/2012. But the other ground, lordship had,
Let us read 27.
the fact of the case is that the applicant is so and so was grievously injured in a bomb blast incident that took place on 2/10/2004 at platform number 1 of.
Yes,
the
yes, madam.
In this case, lordship, it is correct that the doctor was never cross-examined, lordship. So what I suggest, lordship, if the matter is remanded back before the learned RCT to decide the matter fresh, based on the evidence made by the
Doctor is there.
doctor, as per my instruction, doctor,
Then the best way
the
is
matter
to.
be remanded back.
Okay.
Because out of 10 injury, lordship, one of the injury is both ear hearing deficit. And
Now,
because of
that is the
this led to
certificate. No,
absolute deficit.
madam, that is the certificate.
Yes, sir.
That is what the certificate says, and you are claiming. That certificate is issued by a doctor. Let him be cross-examined. Let him come and say,
Nothing proves the doctor.
document, and
One
they'll
chance must
be,
provided.
they'll also get a chance to cross-examine at least. Okay, we'll prove this.
Probably sub rule 2 may come to a rescue.
Rule 3.
Because it deprives a person of all capacity to do work. May help. And in the schedule also, at serial number 6, for absolute deafness, the compensation is rupees 2.
No, 2 will not come because we are only on the issue of adjudication of this further application.
Serial number 6 of the schedule may come.
That's a different matter after the claimant is able to satisfy the veracity of the certificate. The present appeal. Please have your seat, Mr. Sharma. Has been preferred under section 23 of the Railway Claims Tribunal Act 1987 against a judgment and you call it a decree or award?
What?
Award dated 27/8/2012 passed by the Railway Claims Tribunal, Guwahati in way number so and so, Sailable. By the aforesaid judgment, the learned tribunal has awarded an amount of rupees 2 lakh to the claimant applicant with interest at the rate of 6% per annum and further interest in case of delay. Full stop. The appeal is preferred by the railways. Full stop. Para. The facts of the case which emerge from the materials on record revolves around a claim connected with a bomb blast at the Dimapur railway station on 2/10/2004. Full stop. The respondent had instituted a claim before the Railway Claims Tribunal, Guwahati, for injuries sustained by him in the said bomb blast. Full stop. The tribunal, vide the judgment dated 12/1/2007, had awarded an amount of rupees 2 lakh. Full stop. It was clarified that out of the said amount, rupees 1.2 lakhs was under serial number 27 of Schedule 3 of the Railway Accident and Untoward Incidents Compensation Rules 1990, and the balance amount of rupees 80,000 was against 10 numbers of non-scheduled injuries. Full stop. The amount granted was paid, which is not in dispute. Full stop. The respondent thereafter filed an application for enhancement of the amount, contending that he had suffered from permanent disability as his hearing of both the ears were affected. Full stop. The basis of the aforesaid claim was a certificate dated 8/9/2008 issued by the doctor, namely
Eight
it should be a doctor of the Dimapur Civil Hospital, correct? Full stop. The learned tribunal vide the impugned judgment dated 27/8/2011 had come to a conclusion that the respondent claimant was entitled to further compensation of rupees 2 lakhs.
The date of judgment be 27/8/2012.
27/8/2012,
12.
not 11. 27/8/2012. Full stop. Right. The said compensation was paid under Rule 3 within bracket 4 of the aforesaid rules of 1990. Full stop. It is this judgment, comma, as mentioned, judgment which is the subject matter of challenge in this appeal, comma, which has been mentioned above. Para. I have heard Sri B. Sharma, learned standing counsel railways for the appellant. Full stop. I have also heard Ms. M. Sharma, learned counsel for the respondent claimant. Full stop. Sri B. Sharma, para. Sri B. Sharma. Sri B. Sharma, the learned counsel for the appellant, has structured his appeal on two principal grounds. Full stop. Firstly, he contends that the recourse to Rule 3 within bracket 4 is of the rules of 1990 is an erroneous approach. Full stop. Secondly, he submits that without prejudice to his first ground of challenge, comma, even the claim was not duly proved in accordance with law. Full stop. Para. Elaborating his submissions, comma, the learned counsel for the appellant has learned counsel for the appellant, comma, by referring to Rule 3 within bracket 4 of the rules of 1990, has submitted that the application of the rules of the aforesaid provision would only arise when the injured person subsequently dies as a result of the injuries sustained, which was the subject matter of adjudication in the initial claim. Full stop. No, I don't know. Dies out of the injuries sustained. Subsequently dies. No? That is full stop portable. It is submitted that in the instant case, the enhanced claim is only on the basis or is only on a contention that due to the incident, comma, the claimant had suffered permanent disability on her hearing capacity of both the ears. Full stop. Secondly, it is submitted that the basis of the enhanced claim for which the application was filed on 14/7/2009 was a certificate dated 8/9/2008 passed issued by the doctor of the Dimapur Civil Hospital. Full stop. It is submitted that the said certificate was not proved in accordance with law, inasmuch as the doctor who had issued the certificate or any other authorized person of the hospital who would be competent to vouch for it was produced as a witness. Full stop. It is submitted that when the basis of the enhanced claim was not proved in accordance with law, comma, the claim is not sustainable. Full stop. Para. Per contra, comma, Ms. M. Sharma, learned counsel for the respondent claimant, has submitted that even if there is no strict application of Rule 3 within bracket 4 of the rules of 1990, comma, the spirit would be very much applicable inasmuch as an injured who subsequently suffers from further difficulties because of the injuries cannot be left high and dry. Full stop. It is submitted that the approach of the learned tribunal cannot be faulted with. Full stop. As regards the certificate dated 8/9/2008, comma, the learned counsel submits that though the doctor issuing the certificate was not examined, comma, the contents of the same are genuine and it was issued by following the due process of law. Full stop. Para. The rival submissions have been duly considered and the materials placed before this court, including the records of the tribunal, have been carefully examined. Full stop. Para. At this stage, comma, this court has also been at this stage, comma, this the learned counsel has also drawn the attention of this court to an order, to the order dated 20, is it 27? 27/2023, whereby the learned counsel for the respondent claimant was directed to obtain instructions. Full stop. Para. Ms. Sharma, the learned counsel has, however, accordingly submitted that instructions have been received, have been obtained, and the concerned doctor is still there. Full stop. The aforesaid instructions were directed to be obtained on the aspect as to whether an effective purpose would be served if the matter is remanded. in the interest of justice. Full stop, para. After considering the rival submissions and the facts and circumstances, comma, this court is of the opinion that even without going into the technical aspect and deciding as to whether the provisions of Rule 3 within bracket 4 of the rules of 1990 would be applicable in this case, comma, this court is of the opinion that interest of justice would be served if the claimant, no, I don't say, is of the opinion that the reliance on the certificate without the same being proved in accordance with law could not have been the basis, could not have been made the basis for the impugned judgment, full stop. However, comma, this court is of the view that interest of justice would be served if the matter is remanded back, giving the respondent claimant an opportunity to prove the certificate in accordance with law. Full stop. Para. Accordingly, comma, while the impugned judgment dated 27/8/2012 is set aside, comma, the matter stands remanded back to the learned Railway Claims Tribunal, Guwahati, wherein the respondent claimant is to be given an opportunity to prove the certificate dated 8/9/2008 in accordance with law. The records of the tribunal be transmitted back immediately, and the parties are directed to appear on 17th of July 2024 before the learned tribunal, from which date, comma, the tribunal would take charge of the proceedings and complete the exercise as directed above in an expeditious manner. The claimant is also given liberty to produce the concerned witness without praying for issuance of summons.
Just make an apology for making a wrong statement. My lord. Indicated the schedule to be schedule number 3. In fact, there is only one schedule. It's serial number 27 of part 3 of the schedule.
Sure. Serial number 27 of schedule 3, no, serial number 27 of part 3 of the schedule
There is only one,
of part 3, Roman 3.
Roman 3.
Okay.
Right.
Yes,
May
madam.
be the- Lordship, this is lordship for enhancement filed by the claimant appellant lordship. Claimant husband expired lordship due to accident. He was a driver, excavator driver. He died on lordship 18/9/2011. He fell down from the excavator and died.
Okay, he died on 18/9/2011.
11. I have
And
filed claim petition, Lordship, claiming.
You are
50
the wife.
Wife.
Widow is the claimant.
And he has one minor daughter and mother.
Mother also came.
No,
Only the widow had come.
Yes.
Okay. Then what happened?
Lordship, 15 lakhs, Lordship, I claimed, Lordship, and awarded, Lordship, 4,85,000.
Which date? Which tribunal?
Tribunal, Lordship, MSCT, Mongol. Durham. Judgment,
Date of the award?
10/2/2014.
10 to 14.
14.
MSCT Mongoldoy.
Yes.
Awarded how much?
4,85,000.
Okay.
I have filed this appeal, Lordship, for enhancement, Lordship, basically for income. My submission is that, Lordship, income is not properly calculated because he was a driver, Lordship. This is the, Lordship. There is no document regarding his income, Lordship. Wife in her claim petition as well as evidence stated that his income was 8,000 pounds.
Deposition of wife.
Wife. And deposition of PW2, Lordship,
Rupees 8,000.
rupees 8,000. And deposition of PW2, he was also working with the deceased, Lordship. He also
PW2, wife is PW1.
Yes.
Who's PW2?
He is also working with the deceased, Lordship.
Co-worker.
Co-worker. He also gave a deposit that, Lordship, his income was 8,000 pounds. Moreover, Lordship, the owner of that excavator, he was made party, Lordship. He submitted his written statement.
Yes.
In his written statement, he stated that his income was 4,500. So, but Planet Tribunal, Lordship, calculated as 3,000 on national income, and award was done. That is page 10 of my appeal memo, Lordship. How that is done.
What evidence did you adduce that your husband was actually a driver of an excavator?
That was my evidence of PW1 and PW2, Lordship. Wife
What
and husband.
documents?
No,
And
no document, Lordship. And in fact, Lordship, owner also admitted that he was the driver, Lordship, and what? That a WS written statement filed by.
No, if you do not have any document
Yes.
of income, how can you sustain your contention that you are entitled to more than what is to be taken as notional income?
Exactly, Lordship, but in respect, if there is no document, Lordship, there is a judgment, Lordship, that minimum under Minimum Wages Act, Lordship, that can be calculated. If
At-
there is no document,
in
because
the
in
year-
unorganized sector, he was
In the year 2011, how much was the minimum wage?
2011, I have not received any document, but minimum wage act, Lordship, 2017, I have received, Lordship. Here I have seen that, Lordship, 4,095. Semi-skilled, he is a semi-skilled labor, Lordship. 494, Lordship, per month, per day.
No, that is in 2017.
17, before that, Lordship, perhaps
If you can show something of 2000,
2011,
yes,
I have not.
yes, Mr. Goswami, anything can be done.
Another point, Lordship, regarding future prospect, Lordship. So it should be added, Lordship, now as per Pono City, 40%, Lordship, and earlier Santosh Devi, Lordship, that is 30%, that is not added, Lordship. Welcome. This is the judgment of Santosh Devi, Lordship. At that point, that is prepaid, Lordship.
No, see, in Pronouncity, judgments are to be taken in retrospective judgments, not law.
Yes.
Legislation has prospective effect unless it is expressly said, but judgments will apply from, and in some judgments, it is clarified, no, it will be prospective.
But in
Just the other.
Yes.
Legislative has to, by expressly has to say retrospective, judgment expressly has to say prospective. Suppose the judgment of Ramjan Khan, a decision to be rendered on 19th of November 1990. It was explained in the later decision MDECI that it will be from that decision. Otherwise, all inquiry reports will go.
But at that point of time, Lordship, Santosh Devi was there, Lordship, but that 30% also not added. As per Santosh Devi,
Even 30% not added.
no.
Okay, Mr. Goswami, can something be done?
30% has to be at
Hmm,
of the.
hmm.
This is
Now,
the
what-
Santosh Devi judge.
What about the, how much have you been granted? 485? 485?
But the
485 has been granted. Paid or not?
Yes,
Paid to you?
Yes.
Paid to you?
Yes, Lord. I am for enhancement.
No, no,
Yes,
understood.
yes, paid.
Yes, Mr. Goswami, from your side, you say. We will not like to hear your arguments. We'd like to have your suggestion.
the owner had said 4,500, but he also did not come. Somewhere between 3,000.
He did not come.
Yes, 100.
And the written statement he has filed.
Oh, he has not come as a witness.
No. In written statement he has said.
As a line member, please to observe that there is no proof of income and occupation, even the DL was not activated. His ticket was 3,000.
Is, from the awarded amount, is anything remain to be paid? Nothing. You have paid everything.
Yes, that's the point.
Now, where we are asking that even if we think of enhancing, we may go for a lump sum without any interest, but we do not want to settle you with any interest because we don't find any fault. Of course, the part of future prospect may be there.
Yes, sir.
Ah.
But future prospect may be.
You-
Just now I've checked. Whether all enter amount received on.
No, Mr. Goswami has told it was been deposited and
No, Lordship, I have. to
unless
say-
they have an appeal in their name,
Yes. we
there's
have
no
not filed
question of
any
not.
appeal.
Oh,
Yes.
It's a judgment of 2000.
2014, 10 years back,
It must
Yeah.
have paid, otherwise they would have.
gone for
And-
execution or whatever. Yes, can you tell us how much additional amount?
The future prospect plus Lordship may be under 500. As
No, you tell us informally, we'll put it as a round figure. How much enhanced amount? Future pros-
3,500,
Huh?
3,500 as judges plus.
No, how much will be the, how much will be the,
I'll have to check.
please do the calculation. The moment they have not given you the information that they have received, proves that they have received.
Exactly. Lordship.
Otherwise, you would have had sleepless nights.
Yes.
That you have not received the amount.
Yes. And there is no pressure to argue the matter, Lordship, since 2014, otherwise.
Now, if it is decided in your favor, before even you know the judgment, they will know the judgment. Not because of online, even otherwise.
Yes, Lord. Nowadays it is easily available.
এই এসি তো দিয়ে দিবা নি ফ্যানখন অফ করে দিস ফ্যানখন অফ করে দিয়া না ভাই ফ্যানখন অফ করে দেন
Okay. Yes, but. Okay. Okay. But- The private. Yeah, but 56.
Plus.
Point. Eight one. Okay. There are one.
Lordship, the total compensation works out to 6,23,000. We have both discussed the increase the listed and then future proposal.
And out of that, 485 has been paid.
Yes,
Six,
6,20,000. The additional amount. 38.
we'll round it off.
Yes.
We'll make it 150. The present appeal has been preferred under section 173 of the Motor Vehicles Act 1988, praying for enhancement of the award granted by judgment and order dated 10/2/2014, passed by the learned MACT Dorong in MSC case number 36 of 2012, full stop. The appeal has been preferred by the claimant, full stop, para. The claim was made in respect of an accident occurring on 18/9/2011, in which the husband of the appellant, Paresh Gogoi, had expired, full stop. The deceased was a driver of an excavator, and in the claim petition as well as in the deposition, comma, it was contended that the deceased used to receive a monthly remuneration of rupees 8,000. Full stop. The claimant had deposed as PW1 and a co-worker as PW2, and both of them had consistently stated regarding the monthly income of the deceased to be rupees 8,000. Full stop. There was, however, no documents on the monthly income. Full stop. The learned tribunal vied the judgment and order dated 10/2/2014 had awarded an amount of rupees 4,85,000 with interest, full stop, para, with interest at the rate of 6%, full stop. I have heard Ms. P. Bhattacharya, learned counsel for the appellant, whereas the respondent numbers 2 and 3 insurance company are represented by Sri R. Goswami, learned counsel. Full stop. Ms. Bhattacharya, para. Ms. Bhattacharya, the learned counsel for the appellant, has submitted that though there was no documented evidence on the aspect of income, comma, there was appropriate statement in the claim petition supported by the deposition made by her as PW1 and another witness as PW2 regarding the monthly income of the deceased as rupees 8,000, full stop. Additionally, comma, no, she however submits that the owner in his written statement had stated that the monthly income of the deceased was rupees 4,500, full stop. The owner, however, admits regarding the employment of the deceased with him as a driver of the excavator, full stop. The learned counsel submits that the learned tribunal had, however, adopted rupees 3,000 as income per month being the notional income, full stop. It is submitted that in any case, comma, the amount mentioned by the owner in the written statement should have been taken to be the monthly income, full stop. Para. The learned counsel has also structured the present appeal for enhancement on the ground that the aspect of future prospects have not been taken into consideration by the learned tribunal, full stop. By referring to the case of Pranay Sethi, so-and-so versus Pranay Sethi reported in so-and-so, the learned counsel has submitted that the Constitution Bench of the Honorable Supreme Court has laid down the future prospect to be 40%, full stop. It is submitted that even if the aforesaid consideration is made from the perspective of the date of the accident, comma, the case of Santosh Devi reported in so-and-so should have been taken into account, which prescribes the future prospect as 30%, full stop. The learned counsel accordingly submits that a case for enhancement is made out, and accordingly the award is required to be enhanced, full stop. Para. Sri R. Goswami, the learned counsel for the insurance company, in his usual fairness, has submitted that the approach of the tribunal so far as the income, monthly income of the deceased is concerned, comma, in absence of any documentary evidence, comma, the income which was deemed at rupees 3,000 per month as notional income cannot be found fault with, full stop. He, however, submits that the award has not taken into consideration the aspect of future prospects, full stop. He also submits that the aspect of future prospect has to be considered as per the law prevailing at the time of the accident, which was on 18/9/2011. Full stop. Para. The rival submissions have been duly considered and the records of the tribunal have been carefully perused. Full stop, para. The present appeal for announcement revolves around two aspects, namely the monthly income of the deceased and the future prospects. Full stop. The monthly income of the deceased was deposed by the witness for the claimant as rupees 8,000 per month. Full stop. The owner in his written statement had, however, stated the monthly income of the deceased to be rupees 4,500. Full stop. The learned tribunal had, however, taken the monthly income on a notional basis of rupees 3,000. Full stop. In an unorganized sector wherein the employment of persons are not documented, comma, the aspect of monthly income may not be able to be proved by any documented evidence. Full stop. The outlook of the tribunal is to take a reasonable stand by ascertaining as to whether the aspect of employment was otherwise substantially proved. Full stop. In the present case, comma, there was no dispute or denial by the owner, who was a opposite party in the claim regarding the employment of the deceased. Full stop. However, comma, the income which was claimed to be 8,000 was stated to be rupees 4,500. Full stop. The learned tribunal, comma, as mentioned above, had taken the monthly income to be rupees 3,000. Full stop. Para. On the aspect of future prospect, comma, a reading of the impugned judgment would show that such aspect was not taken into consideration by the learned tribunal. Full stop. The Honorable Supreme Court, in the case of Pranay Sethi Supra, has laid down the future prospect to be 40%. Full stop. A judgment would take effect retrospectively in all facts and circumstances, unless a specific observation is made for its prospective effect. ऊपर लिखना, a judgment is लिखना, unlike a legislation, comma, that's a judgment होगा, हाँ, full stop. In any case, comma, even if this aspect is considered from the date of the accident, comma, date of the judgment by the tribunal, comma, The case of Santosh Devi, Supra was already available, as per which the future prospect was quantified at 30%. Full stop. Para. Considering all the aforesaid facts and circumstances, comma, this court is of the opinion that the impugned award is inadequate and therefore a case for enhancement is made out. Full stop. Para. Taking the assistance of the learned counsel for the parties, comma, this court has arrived at a lump sum figure as additional compensation, which is quantified at rupees 1.5 lakhs. Full stop. The aforesaid amount is to be paid by the insurance company within a period of 2 months or 45 days from today in the registry of this court, failing which, comma, the amount would carry interest at the rate of 9% from the date of from expiry of the prescribed period of 45 days. Full stop. The amount be released to the claimant on being properly identified.
Okay.
I think 10 and 11.
Case of the district that contact be passed for the date and be discussed after
There are 14 matter,
next week.
14 matter, not next week. We cannot, these are about decade-old matters. We cannot afford. We'll have this day after tomorrow. But day after tomorrow, even if he's not there, we'll go ahead. And only under exceptional circumstances, we adjourn matters of 2014. We do not. Do Sri R. Goswami, learned counsel for the appellant is present, comma, a prayer for adjournment. A prayer for adjournment has been made on behalf of Sri A.K. Gupta, learned counsel for the respondent. First para. Considering that the appeal is of the year 2014, comma, a short accommodation is granted, directing listing of this matter on Thursday, 20 Tarikh. All right. 12. Dismiss for the lot.
May I plead the Lord? Well, this appeal is against the judgment order dated 19/5/2014, passed in misarbitration case number 444 of 2010, by which the judgment, the arbitral award dated 16/7/2010, in respect of claim number, counter claim, was certified.
Just a minute, Madam Chakraborty. You are the railways.
But I'm.
Railways is the appellant.
Yes, my lord. So, my lord, it will take time, my lord, to long.
Yes, we have time. Doesn't matter. We'll reduce the time, abridge everything. Okay.
So, my lord, in arbitral tribunal,
There was an arbitration case.
arbitration case, my lord, there's some dispute arises regarding the non-commencement of work till the completion date.
The arbitration proceedings culminated in an award
Award
in
is,
favor of the claimant.
no, my lord. the claimant raised 11 claims.
11, okay.
11 claims, and the railway raised the counter claim. So, arbitral tribunal,
You also raise claims.
I am for the counter claim.
You have to raise counter claims. How many?
No, 1 crore,
No, how, was there on a separate heads or
one
head.
counter claim.
counter claim by railways?
Railway.
Then,
Then they claimed 11 claims
yes,
on various grounds, my lord. So arbitral tribunal rejected their claim,
all 11 rejected.
rejected, and the arbitral tribunal.
Award is dated
16/7/2010.
16/7/2010. Award by tribunal,
Yes, my lord.
arbitrator.
Yes, my lord.
All claims of claim, all 11 claims rejected.
Rejected. And the
Your-
counter claim has been accepted, my lord. The 1,61,57,667, because it's the cost
Arbitrator must have been your officer. Your officer.
is, my lord.
Okay. Doesn't matter.
The
Then
panel, from the railway panel, my lord.
thereafter, yeah,
There,
Thir-
my lord,
34 petition was filed.
34, under section 34 was filed, the learned court below, and the
Where
set this award, my lord.
it is in this Kamrup district.
The counter, my lord,
Kamrup district.
yes, my lord,
It was in the district court, Kamrup.
yes, it could come to.
Okay.
So district of Kamrup, my lord, already certified this RBI award, including this counter claim.
And their claim was allowed.
That
11
claim is not allowed.
Okay.
Totally, the arbitral award is dissatisfied.
What is the
Yeah, they are-
date of the judgment?
That's been dated, my lord. See, 19/5/2014. Annexure 2, my lord, in my appeal,
Page
page 25,
25. Okay.
25.
Award set aside by district judge.
Eh,
By which court?
By
Additional district judge.
additional district judge number 1, Kamrup Metro Guwahati.
Okay. Then what happened?
Then now we are telling you the counter claim only. We are entitled to get the counter claim as per the arbitral award, because the work was completed at the risk and cost of the respondent. From the indemnity bond, also it will prove that.
The claimant did not file any 37 petitions so far as upholding the rejection of their claims by the court.
No, they have not filed.
They have not filed.
They haven't filed.
Okay.
Only we have filed, we are agreed with the rejection of the counter.
What are your grounds?
Yes, ma'am. At page 3 of my appeal, the further impugned judgment of the learned court of the district judge Kamrup Metro Guwahati is not according to the law. In fact, is as much as the same has been passed in violation of the terms and conditions of the contract and the provisions of various clauses of general condition of the contract and the provision of the Arbitration and Conciliation Act. Down to further impugned judgment and order dated 19/5/2014 are not based on proper application of the evidence and record as such as terms and condition of the contract as well as the
Do not read the ground. Show us
but the
what-
main ground is, my lord, in what the period? My lord, yeah. In ground number 5, 6, 5, 6, 7, 8, 9. 9 is the important ground. The learned court below failed to take into consideration that on 19/4/2006, respondent applicant intimated the appellant regarding the demobilization of and also request to close the contract. And the respondent applicant confirmed about the state demolition.
You're going on the facts. You address this court on the powers of the 34 court, whether the exercise of jurisdiction was proper. We may not go to the facts. 37 scope is very limited.
Yes, my lord. The total.
It is not, it has come against a 34 application adjudication.
Yes.
You convince us that 34 power was not exercised properly.
Yes, ma'am. Now, we are already taken ground on that we are entitled for the counterclaim as per decision terms and conditions of the contract, because he has himself, the respondent, closed this contract and demobilization his immobilization with the consent of the railway. Then railway has terminated the contract, and where as per the terms and conditions, the balance work to be carried out at the risk and rate of this respondent by the other agent. But that's why this counterclaim has been raised, my lord.
You have done the work through other agencies?
Other agency.
And this is the counterclaim is the amount which you have had to pay to the other for getting the works done by the third agency.
Other.
Okay.
So, my lord, there, but the arbitral tribunal already decided the counterclaim on the same ground, because my lordship will kindly see at page 22, my lord. Counterclaim number 1, risks and cost amount of contract agreement awarded 19 crore 3,66,000. The respondent has claimed the risks and cost amount of contract agreement
Well,
amount.
let us have a look at the impugned judgment under 34.
Yes,
Where
my
is the
lord.
judgment?
Judgment, page 25, man. Annexure 2,
2.5.
2.5.
Yes.
Here, my lord, in para 6, judgment, para 5 and 6, the learned court below clearly discuss, my lord, 5 and 6, and 7. And 7 also, in para 7, it is a counterclaim.
Okay.
The respondent also made a counterclaim of awarding risks and cost of the amount, the amount in
Right,
rupees so and so.
right.
So far my counterclaim is concerned, it already observed in para 7, 24 of the judgment, my lord.
Who is for the other side?
P. Das and Sinha. MS P. Das and MB P. Sinha.
NBP Sinha.
Yes, ma'am.
Who's appearing? B Das NBP Sinha.
Last time also they did not appear, ma'am. On 13/5/2024, case was listed.
Yes,
And
you're
56
correct. You're 4/2/2019. Nobody had appeared.
Yes.
Okay, what is,
Then-
let us see the,
Then I prepared an application for fixing the matter for early hearing, my lord. So listed on 15/3/2024.
no, that is okay. Let us read the award, read the judgment of the
Yes,
learned
in para
additional list.
7. I am not challenging their claims, my lord, because already
Yes,
satisfied.
you have already, you have
I am
submitted that.
challenging my claims. to
You are
counter
concerned
claim.
about your
Counter
counterclaim.
claim, yes, my
Okay,
lord.
yes,
In para 7, page 29,
yes.
the respondent also made a counterclaim for awarding the risks and cost amount of the amount in rupees 19 crore 3,66,000. But during the arbitration proceeding, as being asked by the arbitrators to calculate the.
Has come to 14. Saw pipes have been discussed
Yes, my lord.
and
In
thereafter,
para 14, it is the ONGC versus Soap printed
yes.
cases, or why the planet code below can satisfy this award, my lord. The fundamental policy of Indian law.
Then we have read saw pipes, McDermott have, Burn standard have been quoted, then you come to 16.
15, my lord.
16, 15, McDermott, Bond Standard quoted, discussed. Come to 16.
Yes, my lord. Report in 2006 Relevance STC
No, that is we have read. Come to paragraph 16.
16, my lord.
Yes.
In the case in our hand, in respect to claim number 1 made by the applicant, while the arbitral tribunal had held that due to the first flash flood, the work suffered and hence the applicant cannot be fully absolved of all the responsibility in spite of the fact that soil strata was mainly responsible for such tilt of the tire stroke well number 4. Its rejection of the claim of the applicant does not make any sense and is patently illegal. Therefore, award is liable to be set aside.
Yes.
17 is, my lord, the finding of the arbitral tribunal in respect of claim number 2, that is the claim of awarding compensation for extended stay due to prolongation of job for additional period of 13-12 up to 13-12-2005 is also perverse and patently illegal, inasmuch as the time of completion of the work was extended under clause 17A2 of the general condition of the contract, which relates to granting extension due to negligence on the part of the respondent, and finding of the arbitral tribunal is liable to be set aside. In 18, my lord, claim number 3, claim for compensation due to increase of the price of cement and steel, as the time completion of the work was extended by more than 1 year, 3 months, and as the prices of the cement steel must have gone up during the period. In this stage of the ever increasing general price index in the country was also patently wrong. Therefore, by not awarding any amount against the claim number 3, the arbitral tribunal has committed gross illegality and hence the arbitral award is liable to be set aside as a patently wrong. 19, in respect of claim number 4 and 5, while arbitral
State of
tribunal
case.
has held that the applicant was not responsible for the mistake, rejection of the claim of the applicant does not make any sense, as the arbitral award is liable to be set aside patently wrong. At the time of the completion of the work was extended by more than 1 year, 3 months for the fault of respondent, and for the same, the applicant was compelled to pay the cost of extension of the bank guarantee due to overstay and extension of retention of period of the securities. By rejecting the claim, the arbitral tribunal has committed gross illegality and hence the arbitral award is liable to be set aside. As the arbitral tribunal has refused to entertain the claim number 7 on the ground of rejection of the claim number 1 to 5, which has been held to be patently wrong. The same is patently illegal, and finding of the arbitral tribunal in respect to claim number 7 is liable to be set aside. The finding of the arbitral tribunal in respect of claim number 8 is also illegal, because as per the Arbitration and Conciliation Act 1996, interest is payable on the awarded amount, therefore impute award is liable to be set aside. In view of the above discussion and decision, refusal of the arbitral tribunal to pass award in respect of claim numbers 9, 10, 11 are also perverse and illegal, and hence are liable to be set aside as patently wrong. 24, further, by allowing the counter claim of the respondent, the arbitral tribunal has not only committed gross illegality, but also committed mockery of justice, inasmuch as the arbitral tribunal has held that the consultant appointment appointed by the respondent to find out the cause of sinking of the well number 4 has held that the well number 4 sunk due to differential strength of the soil on the upstream and downstream of the well at cutting edge of the well. Thus, the basic cause of the till has concluded by the consultant is attributable to the nature of the soil, for which the applicant cannot be held responsible. Therefore, how the arbitral tribunal can direct the applicant to pay the cost of constructing the well number 4 till is sinking to the respondent. The respondent must bear the cost of the construction of the well number 4 till its sinking, as the applicant was not responsible for the same. By allowing the counterclaim, the arbitral tribunal has committed gross illegality and hence the arbitral award is liable to be set aside as patently wrong. In view of the above discussion, I hold that the arbitral award dated 16/7/2010 is patently illegal and against the public policy of the country and hence same is liable to be set aside. So, learned court below, without going into the evidence or the condition of the contract as well as the general condition of the contract, passed this judgment. But the learned arbitral tribunal passed this judgment on the basis of the material as submitted by both the parties before the arbitral tribunal and the terms and conditions of the contract, additional terms of contract, and the general condition of the contract, which is on record. So this award is passed on the basis of the record. But the learned court below passed this order with the presumption that there is no it is patently wrong in the violation of the public policy of India. But how it is violated, how it is patently wrong is not discussed.
No, but there is a clear finding that the railways had appointed a consultant
Yes, Madam.
to look into the cause. And consultant had come with a report that there was a differential strength of the soil on the upstream and downstream of the well. And therefore, the fault was not attributed on the contractor. And that was not, there was no role of the contractor in this aspect. And therefore, the delay had happened.
Yes.
And it is a different job that some other natural problems were there, differential strength of the soil in upstream and downstream, and that's a different work. And the learned court has not only set aside your claim made in the counterclaim, but has also set aside the findings in the 10 claims made by the claimant.
Yes, Madam.
So what is the consequence thereof?
So, my lord, from the arbitral award, my lord, it is completely evident that why the railway claimed the recent cost
No,
amount from
madam,
the.
at the beginning, you had contended that you are restricting your appeal only to the counterclaim. But it appears that even the findings in each of the claims by the arbitral tribunal have been set aside by the court.
My counterclaim is not set by the arbitral tribunal.
No. Arbitral tribunal had set aside the claims of the claimant and had decreed your counterclaim.
Yes, my
Now,
lord.
they both were under challenge in 34. 34 has reversed. The claims of the claimants have been held to be, were awarded. Rather, the findings were set aside, and the findings on the counterclaim is also set aside.
Yes.
So, you said that you are restricting your submissions only to the counterclaim.
No, my lord, as my, lordship kindly have a look at my counterclaim, my lord.
No, your challenge
My lord,
is,
in para.
no, madam, your challenge is whole hog or what?
No,
Or
I'm not telling the whole claims, only the counter. They responded.
if you are not challenging their claims, which have been,
I am not telling their claim
have you
because
paid
they are
them?
not entitled. I am already, because since arbitral tribunal decided the matter, they are not entitled to this claim because they themselves have closed requested the railway to close the contract. And
No, madam, saying that will not do. In their application under 34, their claims, the findings of the tribunal, arbitral tribunal, has been set aside.
yes. Yes, my lord. They have filed this petition under section 34, my lord.
Yes.
And in this case also, we filed our objection also. They are raising their claim is not.
Now
correct.
you say that your appeal is only confined to the counterclaim part.
Yes. Now I am here, my lord. I am not going to, I am going against the judgment passed by the arbitral tribunal. But since the arbitral tribunal rejected their claim and I am not challenging this claim when they are claiming that they are entitled for their claim. And after our filing our objection, the learned court below also observed that they are not entitled.
Where?
No, if they are entitled, then learned court below can allow them by setting aside the award,
So it has been set aside on
That-
all the points.
set aside, they set aside. But learned court below set aside our counterclaim also.
That is it. So
Correct.
you are saying that your present appeal is only confined to setting aside your counterclaim.
Yes, my lord.
But the learned court, 34 court, has also interfered with all the findings of the tribunal regarding the 10 number of claims are there. Initially, tribunal said that you are not entitled to any of the 10 claims,
Yes,
whereas railway is entitled to the counterclaim.
counterclaim.
Now that finding of the tribunal has been set aside by the 34
So,
court.
yes, my lord.
Both
And-
accounts, both the accounts,
Both-
claims as well as counterclaim.
Yes, my lord.
Now, how are you restricting your present appeal only to the counterclaim? Just a clarification.
Yes, my lord.
You come to page 32 or 33 onwards, where the claim-wise discussion is made from paragraph 16,
Paragraph in-
page 31.
Yes, my lord.
Please read.
Claim number one,
In
in
the
respect
case,
to claim number one made by the applicant, while the arbitration tribunal had held that due to the first flash flood, the work suffered and hence the applicant cannot be duly
fully absolved.
absorbed of all the responsibility in spite of the fact that soil strata was mainly responsible for such tilt of the tire of the well number 4. Its rejection of the claim of the applicant does not make any sense. And
It's patently illegal.
Yeah.
Therefore, the award is liable to be set aside.
Yes, in so far this claim is concerned, my lord, the railway has extended the time as per clause 17A2 of the general condition of the contract. There is a provision for any measure, force measure condition, railway will extend the time. They have claimed, they have paid for the extension of the time, the railway granted the extension of time. Then later on, they had the letter dated 4/8/2006. They themselves decided to close the contract and demolition their man and machineries. So, my lord, in this, when they have themselves wanted to close the contract, then why the railway will be responsible? In award page 22, my lord, learned arbitral tribunal clearly observed at page 22, para 4.1, the respondent has claimed the risk and cost amount of CA amounting to be so and so, but during the arbitration proceeding, the respondent was asked to calculate the risk and cost amount, again taking into account the rule of risk and cost tenderer. And accordingly, the respondent has worked out the revised risk and cost amount of rupees 11,77,036 11 crores 77,36,500 duly signed by the deputy chief engineer construction signature dated 29/3/2010. Thus, the risk and cost amount is not the same as a claim originally. The well number 4 has tilled when the work was resumed after monsoon in the next working season. The till and strip in the well was within acceptable limit when the work was resumed after monsoon as stated by the respondent. The respondent has requested the claimant to complete the sinking of well number 4 before onset of monsoon up to safe level, but the claimant could not complete the sinking of the well due to poor planning of manpower and material. If the sinking of well number 4 had been completed before monsoon, then the problem of tilt would not have been arises in spite of the fact that there was a different bearing capacity of soil under section and this section as found in the consultant. The claimant is responsible for the tilt to some extent because of his poor planning, which resulted into poor progress of the work. However, arbitral tribunal have further understood that even though the well had not sunk fully, but nothing happened during monsoon. And when the work was resumed after monsoon, the tilt and shift has been recorded by the respondent, which was found within permissible limit. But as soon as graving of the well was started, the well suddenly collapsed, and tilt and shift were very large, which was considered beyond rectification. Finally, the respondent was also not sure of the cause of capsizing of the well, and therefore appointed reputed consultant L&T Ramboll Consulting Engineer Limited to find out the cause of this incident. The consultant in his report has mentioned that the probable cause of capsize, and according to which the well capsized due to differential strength of soil on the upstream and downstream of the well at cutting edge of the well. The basic cause of tilt, as concluded by the consultant, is attributable to the nature of soil, for which claimant is not responsible. The consultant has also suggested the alternative spending arrangement on the request of the respondent, as well number 4 was not possible to be removed from its location. But since the main cause of the failure is due to adverse soil strata over which claimant had got no control, the cost of this alternative arrangement cannot be levied on the claimant. Tilt and shift is the integral part of the well sinking, and such type of risk is always present while working in a river like Barak. Therefore, the implication of such type of risk, the organization like railway shall bear, as the soil investigation has been done by the respondent. And the report was not
Report
indicate,
does not.
the report does not indicate any such adverse feature with the soil. It also transpired during the discussion that only one bore block has been done at each fire location, which may not represent the soil feature of entire fire area, but it is the practice of taking only one bore block at each fire location, which normally represent the area based on which the sinking of well is done. However, since the claimant has failed to achieve the desired progress during the first working season, and the well got filled in the next working season, the cost of the well number 4, which was capsized and had to be abandoned, is to be recovered from the claimant, and as the payment has been made for capsized by well by the respondent to the claimant. The cost of the well, as calculated by the respondent, agreed by the claimant, is rupees 1,61,59,667.10, which is to be recovered from the understanding dues of the claimant and deposit the same with the respondent. Therefore, the arbitral tribunal directed the claimant to deposit the amount with the respondent already received from the respondent towards the work done for well number 4 before capsizing, amounting to rupees so and so, as calculated by Deputy Chief Engineer of Construction 1 Silchar, by office letter dated 3/2/2010.
10.
So, madam, they already respondent agreed that I am failure to complete the work. So I am liable to pay the fixed cost amount. It is from the arbitral tribunal, it is already, they have accepted.
Where?
Madam, the cost of the well calculated by the respondent, agreed by the claimant. That time we are the respondent, and now respondent was the claimant. Agreed by the claimant is rupees 1,61,59,667.
Where is the materials from which the learned tribunal has come to this finding? That there was an agreement?
My lord, there's an indemnity bond, my lord.
Indemnity bond, can you say that it's an agreement?
No, not agreement, my lord. In indemnity bond, they have accepted that, my lord, that the contract died naturally on 13/12/2005, and the applicant sought permission for demolition on 19/4/2006 by letter dated 14/8/2006, intimating confirmation of the demolition. Then another point, my lord, the respondent submitted the contract 11/9/2007 with effect from 31/2025, communicating that the balance work except the bridge approach embankment work would be carried out at the risk and cost of the applicant.
Now, where is the agreement by the claimant, the findings, basis of these findings, that the claimants had agreed to an amount of rupees 1 crore 61 lakhs?
Lordship, amount is not, there's no agreement, my lord, but as per terms and conditions.
No, it
Why,
cannot
what will be the, as his
There can
amount
be-
has been deposited to the claimant.
Madam, there are terms and conditions, but when a dispute arises, you cannot just take recourse of the terms and conditions and say that no, first, but that is the dispute.
Yes,
Where is the neutrality of the arbitral tribunal? Says that as per the terms they have agreed. Where is the agreement? This risk and cost of 1 crore 61 lakhs you have quantified, and you said that they have agreed upon.
but they have not tell, there, in this matter, appeal, my lord, in this peace arbitration.
If there was an agreement, why the counterclaim was objected to by the claimants? They had objected, file objection in the counterclaim. And if you come to paragraph page 22, the last part, that the basic cause of the tilt, as concluded by the consultant, is attributable to the nature, that is soil, for which the claimant is not responsible.
For soil, it is not responsible, really is accepting that. But due to some difference of the monsoon, when he will eligible to complete the work, when not, and he did not work during the monsoon season, when he is capable to complete the work. That's why he was without having any work, he already intimated the railway that I cannot complete the work. I am willing to close the contract. So, and allow me to demolish the man and machinery from the work site. Then accordingly, they have demolished. So the balance, the contract amount which was given to the claimant for completion of the work, and without since they could not complete the work, the balance this cost of risk amount of for the balanced work will be collected from to take back from the claimant, my lord.
Madam, the risk and cost factor is that is not in doubt. But to invoke that clause, you have to come to a finding, definite finding, that the work, balance work had to be done by a third party only because of faults attributable to the original contractor.
Yes, my lord.
If the original contractor is not at fault for not being able to complete the work timely, then can you invoke the risk and cost factor? Why is the risk and cost factor again? That if you are not able to do the work because of your negligence or failure, then we'll recover the cost which we incur for doing the balance work.
Yes, my lord.
Now, there were circumstances for which the claimant was not responsible. The soil turned out to be something, and you had done a survey by a reputed consultant. You had said L&T Ramboll Consulting Engineers Limited.
If there is a difficulty regarding the soil, my lord, when I failed to complete the work, so one total amount of the
No, failure to complete the work will per se invite the risk and cost factor.
No, my lord, because
No.
there is a two monsoon season. He was allowed to work in which monsoon when the soil is completely okay for
Madam,
construction.
we'll have to continue some other day. They had not appeared on the earlier occasion also.
They have not appeared. In the earlier two
But
occasions,
kindly go through your appeal again.
yes, my lord.
Perhaps you are not correct in contending that you are restricting your arguments only to the counterclaim. Even the claims have been allowed. By setting aside the findings of the tribunal, so far as the 10 claims are concerned, means that the claims have been allowed.
If the claimant, they are satisfied.
Yes.
When they are in the indemnity bond, it proves that they will go against the counterclaim. They challenge the counterclaim. When we are claiming the counterclaim, They could approach before the court. So they
No,
have,
no, why should they approach? Counterclaim has also been set aside.
because they have to pay to railway.
It has been set aside
This
by
is-
34 court.
Yes, my lord.
Now it's your appeal.
Yes,
If you're successful in your appeal, then the question of payment will come. But
Yes.
you are restricting your appeal only to the counterclaim.
yes.
The
my-
claims which have been adjudicated in their favor by the 34 court, that you have to satisfy also. How much is their claim? 10 heads. How
Uh,
much? Total?
So that there are 11 claims.
How much is the amount?
My lord, as per arbitral tribunal, my lord. In claim number 1, rupees 200,
How- 200?
200, in page 21, my lord.
200 only?
My lord,
200?
200. 200.00. Then claim for compensation 150. The claim of compensation
Yeah,
due,
those are in lakhs. What are you saying? Man?
no, my lord.
Let us see page.
In page 21, my lord, summary of the claims of the claimant announced by this arbitrator.
In lakhs. Why don't you read, madam? William, they make a claim for 200 in a court.
Oh, a lakh, 2 lakhs.
200 lakhs.
2 lakhs, then 150, then 200 lakhs. I will claim number damage due to the issue of the illegal and wrongful.
See, how much is the
termination.
total? How much is the total?
How much? I have not
Two-
calculated, my lord.
350, 450.
200, 150, 180, 60 lakh, 12 lakh, 86 lakh, 608 lakh, again 200 lakh, 808 lakh. More than
56, 1200, 1200, 2000, 2000, 200, 2300 lakhs. It will be more than 23 crores.
yes. Ma'am. With my contract agreement, as per contract agreement, my lord.
And your counterclaim is only 11 crores. You
No,
still
no,
have
1
to,
crore. My counterclaim is 1 crore.
1 crore. Their claims are 23 crores.
Yes, my lord.
You take instructions on this.
Yes, my lord.
Yes, when?
After vacation, my lord.
After vacation, it's a old matter, 2015.
Then,
Huh?
then I will
Still
not
last-
take place. Except 25, 25, and 25th, there is a number of cases, my lord.
Next Tuesday to last week, no, is that?
Last
Huh?
week also. 28. 28.
17th October. Paucity of time did not permit this matter to be taken up today. List on 17th July.
17 July,
Yes, Tuesday. Oh, no, not 17th, 16th July.
15 July,
16/16.
1/6. Published.
Rest, court master will give dates. Any matter, urgent matter? Mr. Deka, Mr. Shaikia, which matter? MSc appeal. What is it? Item number?
13.
What is it about?
If it is injury case, doctor was not examined, but Thanet trial court had considered.
How much is the amount?
Amount is used on notice 12 lakh, but his injury is not permanent disability.
Who's for the claimant?
So it was
Matter of which year? There is a stay order.
lordship, 50% they have already received. That was the fiction part.
Where is Mr. S.P. Chaudhary? Not there. Okay. We'll have a date.
One date may be fixed.
Okay, we'll fix a date.